We're on the record in case number 2021-00421. My name is Kent Chandler. I'm chairman of the Kentucky Public Service Commission. I'm joined today by Vice Chair Amy Cubbage. For those in the hearing room, please set your cell phones to silent. We ask that for the handful of witnesses we have, as you leave the witness stand, that you wipe it down with the disinfecting wipes. Skip all of that. All right. The hearing today is for the purpose of taking evidence on the proposed amended Mitchell ownership agreement. At this time, we'll have entry of appearance of counsel for the applicant.
Good morning. For Kentucky Power, Katie Glass, the law firm of Stites and Harbison, 421 West Main Street, Frankfort, Kentucky, 40601. Also appearing with the firm of Stites and Harbison is Mark Overstreet. Appearing pro hoc vice is John Crespo, Kristen Blend, and Hector Garcia Santana.
Thank you, Ms. Glass. Will you all be transitioning, moving amongst you, or will you and Mr. Crespo be the two attorneys presenting the witnesses?
The latter is correct.
Okay. All right, for the Attorney General's office?
Mike West for the Attorney General's office, and John Horn is here as well. We also have our witness, Mr. Lane Collins.
Mr. Kurtz for KIUC.
For KIUC, Mike Kurtz, Jody Collar-Combs.
Thank you. And for commission staff?
Nancy Vinsel and Mariah Tussey.
Okay. I checked the record this morning. It looks like the request for to publish the notice went out on March the 18th, and then there was a motion filed the day before yesterday. Is that right, Ms. Glass?
It was last night, actually. We
Okay.
were informed that the Hindman Troublesome Creek Times, although requested to run the notice, did not run the notice.
Okay.
And will not have an opportunity to run the notice before today.
That's fine. So we will get an order out granting that deviation that was requested, but I think from the bench today it's prudent to move forward given the coverage that has occurred in the other 20 counties.
Thank you.
All right. It's my understanding, Ms. Vinsel, that we've had the banner on our website to provide public comments and that no one has signed up. Is that correct?
That's correct.
And looking out amongst the room, I don't see anybody who's not an employee of any of the parties or a consultant to any of the parties. So, seeing that there's no one interested in providing oral public comments,
Thank you.
yeah, oral public comments, I'll just remind anybody who may watch this and is watching this now or watch this after the fact prior to the submission of this case, that they can provide written public comments anytime through our website at psc.ky.gov, or they can email those comments to psc.comment@ky.gov. Again, that's psc.comment@ky.gov. We ask, you could also mail written public comments to the Public Service Commission at 211 Sauer Boulevard, Frankfort, Kentucky, 40601. We ask that any written public comment includes your name, your address, and reference the case number. In this matter, the case number is 2021-00481. Ms. Glass, if there's nothing else other than that motion.
There's one preliminary matter, kind of housekeeping. We realized this morning that only the KIUC have entered into a non-disclosure agreement with the company in this case. And in the event there is confidential information entered into or presented today, there is none currently in the record right now. We would request that the AG enter into an NDA. The only snag is that we don't have the ability to print one here, and was wondering if I could maybe impose upon staff to print one for us, and I can email it. I have it ready.
Before we cross that bridge, does the company intend on doing anything with confidential information related to this case?
No, Your Honor.
Mr. Kurtz?
No.
Ms. Vinsel?
No.
So the only snag, as we may say, is that I do intend on asking Mr. Haynes, most likely, questions about, and I mentioned this, about AEP, Kentucky Power, about KIUC Confidential Exhibit 1 from yesterday's hearing, which is a document for which Mr. Horn and Mr. West and ostensibly Mr. Collin are under a confidential protection for. So does the company have a preference that Mr. West and Mr. Horn enter into a confidentiality agreement related to this case, even though it's for that document?
Yes, Your Honor, because the way the NDA is drawn up, it's case.
It's case specific, yeah. Okay, so, let me ask this other question, Ms. Glass. You have 3 or 4 witnesses today, is that correct?
We have 2 witnesses.
You have 2, just Mr. Haynes and Mr. Kearns?
That's correct.
And you intend on calling Mr. Haynes first?
We intend on calling Mr. Kearns first.
Let's take a short recess, and if you all could discuss that NDA issue, happy to use our printers here if that's necessary. I just would rather go ahead and start instead of starting and then having to stop to do that.
That's perfectly fine.
Okay, so we will take a short recess, an indefinite recess probably. Let's shoot for trying to get this done by 10:30, but if additional time is necessary, so be it. Okay, we'll be in recess. very upset with me.
Ah, well, he'll get over it. You're on, Chairman.
Okay. We're on the record in case number 2021-00421. I just want to correct a mistake for anybody that was watching earlier. Public comment should reference the case number, and again, in this case, that's 2021-00421, not 00481. Ms. Glass, would you like to call your first witness?
Yes, Your Honor. The company calls Timothy C. Kearns.
All right, Mr. Kearns, please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Please have a seat. State your name and address for the record.
My name is Timothy C. Kearns. My address is 2791 North US Highway 231, Rockport, Indiana 47635.
Ms. Glass?
Thank you. Mr. Kearns, can you please state the name of your employer and your position?
Sure. I'm employed by American Electric Power Service Corporation. My position is Vice President of Generating Assets for Kentucky and Indiana Michigan Power Companies.
And did you cause to be filed into the record of this case supplemental testimony?
Yes, I did.
Do you have any corrections to that testimony?
I do not.
So if I were to ask you those same questions today, would your answers be the same?
They would.
Thank you. The witness is available for cross-examination.
Mr. West?
Thank you, very briefly. Hello, Mr. Kearns.
Good morning.
You mentioned in your supplemental testimony that a number of AEP-owned plants have units that are owned by separate companies. Is that correct?
I think I understand your question. I'm struggling to hear you.
Okay, I'll try and speak up. In any of those situations, are those companies on inconsistent trajectories for environmental compliance, like Kentucky Power and Wheeling are with ELG at Mitchell?
In the two examples I cited, no. The Sporn plant was retired, actually Unit 5 in 2013 and Units 1 through 4 in 2015. The reason I picked that for my supplemental testimony was the fact that they did retire at different times, but the reason wasn't necessarily for environmental compliance reasons. The Cardinal plant, the other one that I cited in my testimony, is because it's a joint owned plant. American Electric Power Generating Resources owns Unit 1 and Buckeye owns Units 2 and 3.
That's all I have.
Mr. Kurtz?
I do, thank you. Good morning, Mr. Kearns.
Good morning.
I should know this basic. Wheeling owns 50% of Mitchell, correct?
That's correct.
Okay, does Wheeling own any other power plants?
No.
Okay. The Wheeling load is, do you know how much the Wheeling retail load is per year about?
I'm sorry, I do not.
Okay. The operations of Mitchell, energy prices are higher than they were 6 months ago, are they not?
I would generally agree that they are, yes.
Is the plant running more? What has the capacity factor been in the first 3 months, say, of 2022?
I don't have the number with me. It's been fairly low. We've had some maintenance outages, a couple of forced outages, and right now both units are down on reserve shutdown, so the market hasn't picked them up.
Okay. So they're down for planned or forced outages?
Right now, they're down because the market didn't select them. They're in DNR status or reserve shutdown status. So they're available. They're just not needed.
They're just not being dispatched by PJM.
They weren't picked up in the market, in the day-ahead market.
How have your fuel prices been in the last year, say? Coal's way up. Are you long-term contracted? What is the fuel situation?
Can you help me understand long-term?
I don't know. Tell me about the fuel situation. What are you paying per ton for coal now, or what were you paying 2 years ago?
I don't have the exact number, and I'm afraid that would be confidential anyway as to what we're paying.
Actually, your fuel cost is reported per megawatt hour on various
But
forms.
isn't it reported in the past, not what the contract basis is going forward?
Yes, it's historic, but so what is it, any idea what it's been historic?
Again, no, I don't have anything that tells me what it's been over the last year, or I can give a range, but to give you anything specific for the record, I would have to do
Because
something.
we're arguing a lot about Mitchell, and I'm trying to understand, is this thing worth, how valuable is it? It's not running because it's not being dispatched. That could change That could change,
Sure.
right?
Sure.
So can I interject for a second? Mr. Crespo, Ms. Glass, I just want to make sure Mr. Kearns is not hesitant to respond because he thinks his response is going to be confidential, or if he doesn't know the answer to the question. I couldn't tell by his response.
Yes, I'm sorry.
Go ahead. I think, as,
I wouldn't want to, I don't know if I should divulge contractual information, but I don't have it to divulge at this point anyway, so.
So I think he doesn't have the information, but of course, fuel contracts are filed publicly.
And that may not be it probably is not the case in other jurisdictions.
Any other jurisdiction.
Anywhere else in America, right. So I just wanted to make sure that, because I know he operates in other jurisdictions, that wasn't his hesitancy if he knew the answer to the question and didn't have a concern with that. So, I guess can I direct the witness that if he does know the answer as to what is being paid for coal for a Kentucky jurisdictional plant or a plant owned by a Kentucky utility, that he can divulge that? Is that?
I mean, the
Yes.
contract's filed.
Okay.
yes.
Okay. So I get, with that appreciation that it is not confidential information, if your answer is any different, that's fine. I just wanted to.
My answer is I don't know. I don't have that information.
Go ahead, Mr. Kurtz.
Thank you. Trying to think if I don't want anything else. So when the plant, PJM is not dispatching Mitchell now, how much advance notice do you get? Is this a daily dispatch decision?
Yes, we put an offer in daily for the following 24-hour period, and we're notified early in that day as to whether we were picked up for the following day. And if we are picked up or the market selects us for the following day, we'll go into startup.
Is the plant basically kind of on idling, sort of at a minimum amount, getting ready to go for tomorrow if it's called?
No, it's in cold shutdown right now, so you would have to put all your systems in service and get everything warmed up, and it's roughly a 24-hour period.
Okay. And when it's not being picked up, the workers do what?
They'll do preventive maintenance work. You still have a lot of equipment checks that you do to make sure that the equipment is ready when called upon. Depending on the amount of time that you anticipate being out of service, you do certain things proactively to make sure that you don't have out-of-service corrosion in the equipment and things that would cause future forced outages. So it's really just a shift in the type of activities, not that you do nothing.
No, I get it. Any expectation about what might happen this summer, or would that just be a pure guess? In terms of the plant running or not running?
Yeah, we certainly expect it to run. We expect, summer and winter are the months where the energy market is the most volatile and where we think we provide the most value for the customer. So we certainly expect to run during those times.
Well, we have capacity factor. Staff introduced this yesterday as an exhibit through 2021. So, and then let me just sort of build it for the first quarter of 2022. What type of capacity factor did Mitchell Unit 1 and Mitchell Unit 2 have?
I don't have those numbers with me, but they are sub 30%.
Okay. Okay. Thank you, Mr. Kern. Thank you, Chairman.
Ms. Vincel?
Thank you. Good morning, Mr. Kearns.
Good morning.
I hope you can hear me all right.
I
I'm
can,
generally
thank
pretty
you.
soft-spoken, so I have a few follow-up questions to some of Mr. West's questions regarding the co-ownership of the subsidiaries. Could you describe, based on your experience, some of the operational problems that arise when there are co-owners of a facility?
I'll be honest, I'm not aware of any, because the way we manage that is you have, in the case where you're in a situation with a non-affiliate, you have an operating agreement or some agreements that guide how that happens. That would be in the case, say, of Cardinal. In the case of the Sporn plant that I mentioned, they were owned by Appalachian. The units were owned by Appalachian and Ohio Power. Appalachian Power owned units, 2 of the 5 units. Ohio Power owned the other 3. And so The units were all dispatched independently. They were maintained independently, yet they shared some common equipment, like a barge unloader, a coal pile, any number of other common equipment, common air systems. So the splitting of those costs, the accounting for and the allocation of those costs was handled, in the accounting system with work orders, and if folks charged time to this work order or this piece of equipment had work done to it, then charges went to the right owner.
Okay, so based on your experience, most of the problems, if any, were resolved through the operating agreement, through terms and then a dispute resolution in the operating agreement.
Yes.
Okay. I believe that's all I have, Chairman.
I'm sorry, I would offer that even in the case of Mitchell, with the operating agreement that we have today, we haven't had any disputes or dispute resolution clause, but we haven't had, or section, but we haven't had disagreements. It's all been we've been able to handle that, and maybe it's because we're affiliates, the two companies are affiliates, but no issues.
Okay, thank you.
Vice Chair.
Yeah, I just want to try to figure out, just in a practical, logistical sense, how this would work.
Okay.
I'm presumably at some point soon, regardless of what form of agreement gets approved, Wheeling's going to become the operator and the permit holder for air permits, water, all of that good stuff.
That's correct.
So if we get to 2028 and there's this unit swap, presumably Wheeling is still going to hold the operating permits and the other unit owner would contract? How would that work?
Ultimately, that would be for the operating company to put on the table. But I don't think it would be different than the situations that I just described, where the units are already separated. They share some common equipment. So the operating committee would need to decide how to allocate or charge those costs to the right unit. And then I'm assuming some billing process to the non-operator owner, or however that gets paid. But again, that would go to the operating committee. I don't see it any different though than what we do today at some of our other facilities.
Okay, so Wheeling could stay the operator even if Kentucky Power owned one of the units outright?
That's my understanding, yes.
Okay. And then presumably if we get to 2028 and there's not a change in EPA regs and we still have ELG requirements, that unit's either going to have to shut down or be upgraded or sold, right?
Yes.
Okay.
Yes.
Okay, that's all I've got. Thank you.
Morning, Mr. Kearns.
Good morning.
You were here for our March 1st hearing, correct?
I was.
And you remember they're the documents that you all file. I know you all file them, but Kentucky Power files documents regarding the Mitchell Generating Plant performance data. And you were asked about that performance, correct?
That's correct.
You were asked in that case about the difference between Unit 1 and Unit 2 and the operations of Unit 1 and Unit 2, correct?
That's correct.
And I think the exhibit went back 5 years.
It
So
did.
2021 all the way back to, make sure I've got this here. Yeah. All the way back to 2017.
Yes.
And so the forced outage rate of Unit 1 has never been over 10%, or Unit 2, excuse me, has never been over 10% in any of those given years. And varies from 1.96 to 9.89. And Unit 1's forced outage rate has gone from a low of 12.14 in 2019 to a high of 43.9 in 2021. So do you remember being asked, paraphrasing here, but being asked in 2020, being asked which unit you'd prefer if you had to pick one, and your response being probably Unit 1, given the amount of investment that's occurred in it?
I don't remember that being my response. I believe what I remember my response being, or what I intended to say, was that from this data, I wouldn't have a preference one over the other because of the maintenance cycles and knowing the investments that have been made in the units and what's coming. And so for Unit 1, I'll pick that one and pick 2021. It had the 43% forced outage rate, 43.9% forced outage rate. 43% of that forced outage rate was from the GSU failure. So if you take that out, that forced outage rate is down at about 20%, and that's not even the actual number. I haven't calculated it, but E4 is calculated based on the service hours plus the derated hours. The denominator in the equation is actual service hours plus the derate hours. So what I'm getting at is that to make a decision simply on these 4 or 5 parameters for a 5-year historic period is not what I would make my decision on. I think you would go through more of a due diligence about the remaining investment, what are those big things that are needed, what's been recently replaced, and that kind of, and those type of things, and not on this. So I wouldn't make my decision on this criteria over the last 5 years.
Well, and I'm not, well, I appreciate that, because that is not how I understood your response to be in the March 1st hearing.
Okay, I'm
when you
sorry.
started talking about maintenance cycles.
Yeah.
Even if, with the exception of one failure, which I don't know if that's reasonable to take that out as an exception, or if that's something that, could happen to other major parts of the plant. 20% is not a particularly good forced outage rate. Would you agree?
I agree.
And for a 5-year period, never having been below 12.14 is not particularly good. Would you agree?
I agree.
This is going to be a weird question, but I'm not artful, nor am I an engineer. What is wrong with Mitchell Unit 1 that it is operating, just even relative to Unit 2, at such a disadvantage over the past 5 years?
I don't know that I would say that there's anything wrong with Unit 1. The performance of the unit is certainly needs to be improved. And we have plans in place to address those liabilities. My point about the one failure in 2019 was more to illustrate that if you look at what causes the forced outages, there are several, both for Unit 1 and Unit 2, that were created by a single event, large event, whether it was a turbine failure in 2017 on Unit 1, a turbine blade failure, or this GSU failure. Unit 2 has had, similar things. And you can't, because EFOR is EFOR, right? But if I'm looking at which is the better unit or which unit I would prefer, I want to get back to what caused the outages and why is that number what it is. If I were to pull out those 1 or 2 items that are single big events over this last 5-year period, I would offer that the forced outage rate between the 2 units, there's only a 4 percentage point difference between the 2. Unit 1 being around 13%, Unit 2 being around 9%.
But 13 is still not good.
It's still high. I agree.
And that's why, you say nothing's wrong, but something's not right. Would you agree?
Yeah.
You 1 or 2 instances, but it seems like we've got to, I'm not one to attach onto 1 or 2 data points, because they don't make a trend.
Right.
But this is data going back half the time that Kentucky Power has owned Mitchell, and I don't know, I guess I can go look in this 2012 docket. I don't know what the performance is the 5 years prior to this, but this is half the time that Kentucky Power has owned Mitchell, right?
Sure. Sure.
And I'm sure you've heard enough testimony to appreciate that you as a general matter know what a megawatt hour costs at Mitchell, right? You have,
Yes.
as a coal plant, as opposed to a gas plant, you have significant control over the cost inputs into a coal plant, right? Like Mitchell. You know what the fuel is going to cost because you've already purchased it, right?
That's right.
So you know what you can produce a megawatt hour for. And you know what customers are going to have to be charged for that megawatt hour through their retail rates as a fuel adjustment clause. Fair enough?
Yes.
Okay. But in the event that customers need power and the generators that they own and they're paying the fixed cost for aren't operating, they're subject to market rates, right? Because you have to buy replacement power. Would you agree?
Yes, I agree.
Okay. And so any time that Mitchell is not operating and that customers are subject to having to purchase market power, that's a risk, right?
Yes.
And I don't mean risk as in only downside. I just mean risk as in a deviation from the status quo or the expectation.
Yes.
Okay. And so you talk about going forward, this may not necessarily be reflective, but certainly the high forced outage rate over the past few years has presented customers with a higher degree of risk as opposed to a lower forced outage rate. Would you agree?
I agree.
Looking at, or hearing your answer, what is this plan that has been put into place to address the concerns regarding, the significant unavailability of the Mitchell plant?
So the plans are the same, are evaluating the condition of the equipment, studying what's caused the unavailability and addressing those. You asked, what's the issue been with Mitchell 1? The issue has been primarily around the precipitator and some of the back end of the boiler and the flue gas equipment. Burning the high sulfur coal over the years has caused corrosion that all jumped up, that we saw curtailments and forced outages around that equipment. That's been the main part of it.
Well, so let me ask, will you be changing the type of coal? Have you already changed the type of coal you burn, given that that's an impact?
That type of coal change, we burn a blend because of the scrubber. We burn a blend of high and low sulfur coal. And so we already have changed that, but this is a process that starts when the unit goes in service and you're burning high sulfur coal in 1971, right? This doesn't happen overnight. It's something that happens over time. And
Well, but the equipment failure you're talking about, is that equipment that's original in 1971?
yeah.
Okay.
The
It hasn't been replaced since then?
No,
The
this is
precipitator.
a major piece of equipment, the electrostatic precipitator that removes the particulates from the flue gas. And as the temperature of that flue gas drops below roughly 270 degrees, you form sulfuric acid from the SO2 that's in the flue gas. And you're putting acid through the system. So every time you start up and shut down, you cross through that temperature, and you have corrosion that starts from that. And so that's 40 years at the time, and now 50 years worth of corrosion that we're dealing with. So that's been the prevailing problem.
So is that your FGD that you were talking about?
No, the FGD was put in service.
Would you be surprised that it initially put into service in 2005?
Yeah, no, I'm not. That doesn't surprise me at all.
Okay, so it's not the SCR you're talking about either?
No, it's the precipitator that removes the fly ash, the fly ash particulates from the flue gas
Okay.
before it gets to the scrubber.
Would you be surprised, would you be surprised to know that the electrostatic precipitator has been upgraded at least 2 times in the last 8 years to the tune of nearly $2.4 million?
No, I wouldn't be surprised because I know what those upgrades consist of, and it's going in and replacing wires and plates. It doesn't necessarily replace those upgrades, not in every case, or both cases. included all the casing, the wrappers, the wrapper controls, the rectifiers. So upgrade is not really a complete
Okay.
refurbishment or
What about the Precipitator Modifications in 2002 and then again in 2006? Or there have been a number between 2006 and 2020 to the tune of $12.6 million.
Again, I'd have to go back and look at what the scope of those were, but those, it's not replacing the precipitator. There's a lot of duct work and casing and hopper work, and typically the failure mechanism for a section in the precipitator is the wires or the wrappers, the parts that actually charge the particles for collection.
Okay. And as a result of what you were saying earlier, that you all have invested a good amount in the coal blending facilities, would you agree? As a way to address, I assume, that sulfur content, the different contents of the fuel?
The blending is, yes, we're burning, the blended coal has a lower sulfur content than before the scrubber. That's true.
And that, would you be surprised that over in early 2000 and then again in 2019, that there have been $16.5 million of capital put into the coal blending facilities?
No.
I guess the reason I ask all this is these are not just problems that make the unit unavailable, and it requires then the company to buy replacement power on the market. Every time it's unavailable, every one of these problems probably has to have a capital fix and an O&M fix. Would you agree?
Yes, agree that it's one or the other, and maybe a combination of the two at times. It depends on in what section that problem is occurring.
It doesn't normally break and result in a forced outage that doesn't ultimately cost anything to fix. Is that fair enough?
That's fair.
Yep. And how much has that cost? Like, have you all looked at the difference between at the cost impacts of forced outages as a result of resulting over the last 5 years? What the replacement power was above or below what the production would have been from Mitchell, or the cost of the fix?
I have not made that comparison.
Okay. Do you know who would have at AEP?
I don't.
Do you know if anybody does?
I would want to talk to the Kentucky Power leadership and see if, as part of the fuel, the FAC, or as part of any other analysis that they do, if that's part of it.
Well, so who does the going forward analysis to figure out whether the stay open cost of generation is outweighed or above or below the replacement cost of generation for terms of resource planning? Are you involved at all in that process?
No, that's our strategic planning team. I mean, I'm involved from an informed standpoint, but it's a strategic planning team that looks at all the inputs and the going forward prices and cost of replacement generation and all that. And
Let me ask this, Mr. Kearns. In your position, are you ever requested to provide information on how expensive it is to continue to fix facilities to keep them in operation as an input to that calculation?
yes, and it's our forecast. You know, our 10-year forecast is what feeds, say, the IRP process.
Okay, and do you, as part of that 10-year forecast for, I assume, capital and O&M costs related to these facilities, do you take into account an anticipated failure rate or forced outage rate that will result in additional costs?
We do.
And is that informed by past failure rates, or is that informed by some general ratio or metric?
It's informed by both past and what we expect going forward based on the condition of the equipment through inspections and the folks at the plant knowing that condition and what we need to replace.
Okay, so you all, is it clearly delineated what those costs relate to when you provide them as a forecast, or are you all just giving them a dollar per kW or a fixed dollar per year number?
It's a fixed dollar per year number,
Okay.
but
Is it
broken down
somewhere?
by projects, right?
Okay. So do you have in there, for instance, a line that says, we expect the probability of a significant failure of the precipitator is going to happen one of these years. We're going to pick year 4, it's our expectation, and here's what the cost of fixing that would be unexpectedly.
Yes.
Okay. Would you be able to provide that if we requested that 10-year broken out in the manner we just discussed as a post-hearing data request? Is that a document that you're able to provide?
The forecast broken out by line item?
That's right.
Yes.
Okay. Can we ask it as a post-hearing data request? All right, I appreciate it, Mr. Kearns. Thank you very much. Ms. Glass, do you have any redirect?
Just a couple. Mr. Kearns, I want to go back and follow up on some of the questions that Mr. West was asking you, and my questions relate to the Cardinal plant. And the Cardinal plant's owned by more than one owner, correct?
Yes, that's correct.
And is it true that AEP wants to retire the Cardinal plant by 2030 and Buckeye Power wants the plant to continue to operate after that date?
I can't answer that. I haven't been in those discussions. I just know that the Cardinal plant, we are owner of one unit and Buckeye owns the other two, and I selected it because of the joint ownership, but the future plans of that plant, I don't know.
Okay, thank you. Mr. Kearns, as far as the unit swap would go and choosing between two units in the future, can we reliably predict now what unit may be more desirable for a number of reasons in 2028?
No.
Many of the projects or components that you were discussing with the chair at the Mitchell plant have been filed with the commission in environmental compliance plan filings. Is that correct?
That's correct.
And is it your understanding that the commission has reviewed and approved those investments and their recovery through the environmental surcharge?
That's my understanding.
Those are all the questions I have.
Thank you very much, Mr. Kearns. Please step down. Can I ask, as a personal matter, Mr. Kearns, do you have an early flight out today? I assume you're driving to Rockport, but I don't know there's a lot of flights into,
That's true. There's
It's
not.
a
No,
problem.
I don't.
or that many people fly from Lexington to Evansville. So if you could, although I'd ask you to step down, if you'd stick around in case you need to be recalled, I'd appreciate it. All right, Ms. Glass, Mr. Crespo?
Yes, the company calls Steve Haynes.
Mr. Haynes, please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Please have a seat. State your name and address for the record.
My name is Stephen Haynes. My business address is 1 Riverside Plaza, Columbus, Ohio, 43215.
Mr. Crespo?
Thank you, Your Honor. Mr. Haynes, by whom are you employed?
I'm employed by American Electric Power Service Corporation.
And what is your title?
My title is Senior Vice President, Strategy and Transformation.
And Mr. Haynes, did you cause supplemental testimony to be filed in this case?
I did.
And do you have any changes to your supplemental testimony?
I do have one correction to the supplemental testimony.
Would you please go through that change, Mr. Haynes?
Yes, on the supplemental testimony, page S9, we have a sentence that actually begins in line 3. And in line 5 of that sentence, it says buyout transaction is not approved but not consummated. And we need to delete the first not so that it says buyout transaction is approved but not consummated. So just delete the word not.
And Mr. Haynes, just for clarity, would you just read the entire sentence into the record, please?
Certainly. So the corrected sentence would read, in addition, if the owners enter into a buyout transaction on mutually agreed terms but aren't able to obtain the necessary regulatory approvals by May 1, 2025, parenthesis, or if a buyout transaction is approved but not consummated, end parenthesis, then the owners are also required to enter into the unit interest swap on mutually agreed terms.
Great, thank you, Mr. Haynes. Did you have any other changes to your testimony?
That's my only change.
And with that change, if I ask you the same questions in your supplemental testimony today, would you have the same answers?
I would.
Thank you, Mr. Haynes. With that, Mr. Haynes is presented for cross-examination.
Thank you, Mr. Crespo. You know what I'm going to ask, that if in the next week or so, if you all could file an errata to Mr. Haynes' testimony, I would appreciate it.
Yes, Your Honor.
Thank you. Mr. West?
Hello, Mr. Haynes.
Hello?
Can you hear me okay?
Yes.
Okay. Under the revised ownership agreement, prior controversies about valuation are avoided because Kentucky Power and Wheeling would either agree on a price, or the units would be divided, correct?
Under the newly revised version, again, the options go even beyond that, because they could agree on a price, or they could agree to vet the operating committee to retire the unit, or they could agree to split the units so that each one has a unit. I'm not sure if I really answered your question, though.
Well, if there's no agreement on price, the units will be divided, correct? That step will be taken.
That would be the next step that you would proceed into, correct?
Okay. Can you walk me through Kentucky Power's thinking about how that unit swap would be carried out in practice?
Yeah, really, in practice, again, as the agreement says, we would expect them to try to negotiate, but to your point, you haven't negotiated the buyout transaction, so you would proceed to work out the terms. As if you look at especially as Exhibit C, there are a number of terms you need to work out. You need to work out which unit is each party getting, is based on which unit each party is getting, is there any payment between the two parties, because there may be a difference perceived or determined in value between the two units. So is there a payment between one party and another? In addition, you need to work out the arrangements for the common facilities, because, are we agreeing that we're going to continue with the coal procurement the way it is, so those facilities as well as the other facilities. And then if Kentucky Power wants to keep running the unit, or we believe under this, there's also an option to sell a unit, because Wheeling Power and the West Virginia Commission has ordered the ELG to be constructed by Wheeling, but this commission has ordered that Kentucky not be constructing the ELG facilities, then there would need to be some agreement. So if you want to run the unit, or if you want to sell the unit to another party so that it runs past 2028, you need to have some arrangement to be able to use the ELG facilities. And again, we're, as you know, those details are not here to try to determine that arrangement, but again, it could be pay as you go, it could be pay up front, Wheeling's investment, whatever that's determined to be. But the point is, you need to work out those arrangements. And then you also need to work out the arrangement of, if Kentucky determines after 3 years, 2 years, 1 year, you know what, we've been running our unit, but now we're going to close our unit. Or if Wheeling decided to do that, then you would need to determine, okay, make sure it's safe, what your unit as it sits there, and then when is decommissioning going to occur? How are we going to pay decommissioning? Are we going to pay it up front? Are we going to pay it when it occurs? And again, making those arrangements, and again, the operating committee be essentially arranging, making sure that both parties are satisfied with those arrangements. And so you've worked through the split, how the operation is going to go and whether it's going to run, and then how is it going to, at the end, how is it going to be retired and how decommissioning is going to be paid for. So I believe, again, Exhibit C lays out many of those pieces.
Okay. I think for my next few questions, I'm going to read a statement from your testimony to set up my question. If I make any errors in the way I read that, please correct me. But I'm going to start on page 6 of your testimony. And you say, Kentucky Power and Wheeling would need to determine if a mutual agreement can occur by May 25th, 2025, so that their determination is synchronized with PJM capacity planning cycle, under which generation capacity commitments are generally made 3 years in advance. Is that correct?
I'm not seeing the exact words, but basically you do need to determine, and PJM lately, of course, has not been on that exact normal cycle, but you need to generally determine 3 years in advance capacity.
So the addition of the unit swap mechanism requires the parties to make a decision sooner than under the previous version of the ownership agreement, where a default or fallback buyout decision could be made later, correct?
Yes, and working through, we, of course, as I say in my testimony, the reason we came up with this unit interest swap option was because we got input from parties that the buyout was not preferred, but we also realized it would be really important to align with the PJM process and ensure that parties are making decisions early enough so that there is certainty to be able to bid into the PJM, whether it be FRR or RPM, whatever it is, to be ready for those auctions and process. So that's why we really had built in this timeline into there. It says if the buyout hasn't occurred by the end of 2024, you need really to be working and then going into a regulatory process for approval, then you need to I'll say, pivot to working on the unit interest swap so that you can have at least what I would call in principle, an agreement by the May timeline for the May auction for that next 3-year out auction period, so that you can be able, each party can determine, all right, I'm running my unit, I know what to do, we've got an agreement on the split, or I'm going to shut down my unit, whatever I'm doing, and then you could even post that period of time, work out the rest of the details around the common facilities and all that. But you really would need an agreement in principle of what you're doing and what your plan is for your unit by the May 1, 2025.
Okay. On page 7, you list the options that Kentucky Power would have under the revised ownership agreement, which includes the unit swap proposal. The third option is to split the units and operate the unit with a newly executed agreement to utilize Wheeling's ELG assets, correct?
Yes.
Does the revised ownership agreement dictate how that newly executed agreement would be created?
No, it does not.
Would it be created by the operating committee?
Yes, and many of these things, it is noted that the operating committee does take on a lot of responsibilities in this process, but it is not told exactly how to do that ELG agreement. What I would note is really similar to what's happened in this process, where commercial people were involved, legal staff was involved helping the operating committee with these agreements. I would expect the same thing to occur at that time, where you would get the right and regulatory people, whoever needs to be involved in crafting that ELG agreement, they would need to be involved. But we would expect the operating committee to take the lead in crafting that agreement.
Okay. I think I know the answer to the next couple of my questions based on what you just said, but I still want to ask them.
Sure.
Are there any statements in the revised ownership agreement which would provide Kentucky Power the right to effectively rent ELG equipment on a year-by-year basis?
Again, it's not dictated, so I'll say, to me, that is an option that is there on the table. Again, I'm stating these things because I believe both parties, Kentucky and Wheeling, don't want to get into the fact they could easily see that, okay, if Wheeling is invested in ELG equipment and sells it to Kentucky, you may create accounting ramifications, rate-based ramifications, but if it's rented to Kentucky, perhaps that would be the easiest path if Kentucky wants to say, I want to run my unit and I want to be able to use the ELG investment at Wheeling, but then both parties can benefit, so that Wheeling could, I'll say, get appropriate payment for its assets, but that Kentucky can then have that option to run its units. So yes, I think a rental approach could be very advantageous to both parties to make that work. But again, the details would still be available. It's not dictated in this agreement.
Okay. On page 10, you say Kentucky Power and Wheeling Power could agree to pay decommissioning upfront or over time as costs are incurred when the whole plant is retired. So does the revised ownership agreement provide any limitation or standard for how or when decommissioning costs are paid by Kentucky Power?
No, it does not dictate the how or when, and especially we did get feedback, and we made it very clear here that we heard the feedback that we not dictate, similar to the buyout provision with the fair market value approach, where we said pay for decommissioning up front. We got heard loud and clear that people wanted flexibility around how they pay for the decommissioning, because there could be different views on how costs change and different views on what is optimal. So the decommissioning timing, of course you can't pay for it after, but you need to pay it for it at least no later than the timing of decommissioning, but we're giving flexibility in this version of the agreement.
So that's left to the operating committee, correct?
Correct.
On page 10, you also say, if Kentucky Power plans to operate the plant past 2028, then an adjustment to settle the common facility costs will have to be made to account for ELG and any other investments that Kentucky Power did not share in equally as appropriate. When you say the other investments that Kentucky Power did not share in equally, are you referring to the costs for the investments that wouldn't have been made but for Wheeling's intention to continue operating past 2028?
That is correct. Again, we have in the agreement this arrangement where Wheeling has made it clear it wants the option to run past 2028 and is investing in capital investments. that enable the plant to continue to run. So only the ELG or any unequal, in other words, not 50/50, capital investments made between the approval of this agreement, assuming it's approved, and 2028 would be the only things that Kentucky has to, I'll say, catch up on paying. But again, as with ELG, I believe the arrangement can be determined at the time of, right? It could be, again, should it be a rental or should it be buying out the investment, can be determined at a later date. But yes, that's the only those are the only other investments envisioned by this comment.
And I think you referenced this, but you also said the operating committee can determine the amount and timing of payments, lump sum, or installments. Does the revised ownership agreement offer any guidance on what costs would be divided, how they would be divided, or how and when those costs would be paid?
No, it really does not dictate that. Again, assuming both units are running, obviously we expect many things to be arranged so that it becomes a 50/50 like arrangement, but it's not dictated specifically. It's expected that, again, the operating committee will get its technical experts together to determine what the right thing to do is, but it's not determined in this draft of the agreement.
Okay. Let's talk for a second about.
Mr. West, are you transitioning to a different topic?
Yes.
Do you mind if we take it?
Go
I'm
ahead.
not going to throw you off
Go
and take a break
ahead.
now.
Go ahead.
Great. All right, so we'll take a short recess until 11:45.
Okay.
Ready?
Mr. West, would you like to continue?
Yes, thank you. So my next question is about due diligence. If the unit swap is triggered, does the revised ownership agreement say anything about whether due diligence or a certain amount of due diligence related to the units would be conducted in common with the cost shared?
So, I mean, due diligence, I would expect to be something that would be kind of required, because when you look at, for example, back to Exhibit C, Bullet 2, notice it talks about the payments, and then it's, value attributed to each unit. As part of that work to attribute that value, for example, and to, such as the discussion this morning about the units, you would clearly have to do due diligence work, which the operating committee could lead, or each of the owners could lead on their own to determine that value. So again, it doesn't specifically say there's due diligence, but again, the process would allow for that to occur.
Okay. And the operating committee would work out whether those costs would be shared or incurred by the respective companies?
Yes, yes. A part of your question was related to the common facilities, absolutely. So part of the diligence would be, all right, as we go forward with these two different units, what do we see in the common facilities, whether it be the coal side or the ash handling side, all those different pieces, making sure that the cost allocation is appropriate going forward.
Mr. West, can I ask your indulgence for a second? Do you mind to push the microphone a little further away from it? Same thing with you, Mr. Haynes.
Oh, sorry.
I don't think this is the group that we have problems with hearing. I'm also going to ask just give them a second to see if they can turn the volume down, because there's quite a bit of feedback.
Okay.
Oh, sorry about that.
Just hold on 1 minute now. See if they can do that. Testing. Okay.
Okay. Does the revised ownership agreement contain any provisions that compensate either company in the event they receive the lesser unit in the swap? I think it's been referred to at times as a make-whole.
Yeah, again, make whole can have different definitions in different contexts, whether it be related to a bond or related to other commercial arrangements. But again, I think, as was noted there in Exhibit C of the revised agreement, you really have the opportunity to work on an arrangement to make a payment. It says payments, plural, so I don't think it's trying to predefine whether it's one payment up front or multiple payments over time. In other words, I think it could be an arrangement that says, well, I thought I got the better unit, but you really got the better unit, so perhaps there needs to be a payment at a later date, which perhaps is why you're calling it a make whole. I got the worst unit, make me whole. So again, I think that the agreement allows for any form of arrangements between the two parties, so that both parties can view after the fact, an ongoing basis, that they got a fair arrangement and both owners are satisfied with the agreement.
Does the revised ownership agreement dictate the form of the transaction that will be utilized to effect the swap?
One of the things that we did as part of this was to not be too definitive up front when things can change over time. Any number of things, whether it be the market environment, the environmental regulations, these things can change. And so what we didn't want to do is say, well, this transaction, here's a unit interest swap agreement, and so here are all the details, and do it exactly like this. Again, we're really leaving it with the operating committee and any advisors they bring on to work through those details until it's done. So there's no structure. Again, the only structure we've defined is what we've laid out here, which is each party ends up with each unit and works out the access to the common facilities, works out the cost allocation. Is there any difference in value that needs to be paid between the parties? And then, of course, the decommissioning and retirement at a later date. So, again, it's really leaving that for the parties to work out.
Okay. Do you have your testimony available to you there?
I do.
Okay. What I'd like to do now is, if you could turn to STH-S2, which is the redlined version, the marked up version of the revised agreement.
Yes.
I'd like to just walk through that document and ask some questions about some specific changes that were made. So let's start at page 4 in section 3.2, and this is page 4 of the document,
Oh, okay.
not page 4 of the exhibit, if that
Right.
makes sense.
Can you re-identify the document, Mr. West? for our
Yeah, this is
benefit?
the marked up version of the revised operating agreement that's exhibit STH S2,
Page 440.
page 6 of 40, which is
Okay.
page 4, by the page numbering on the bottom of the document.
Thank you very much.
Yeah. And in section 3.2, my question relates to decommissioning has been modified by the word relevant in the middle of that paragraph. Do you see that?
Yes.
Okay. Can you describe the intent behind that change?
Adding the word relevant?
Yes.
Sorry, I need to read the context here to make
Okay.
sure I don't misstate anything. Yeah, so again, because of the unit interest swap arrangement, before, when there was a buyout transaction, Wheeling had full control of decommissioning the site, right? So now you have two owners who may decide each to run a unit past 2028, right? So now we may have one unit owner deciding in 2029 or 2035 to close their unit. So then you need to decide, am I decommissioning that unit at that time or waiting until the entire site is decommissioned? So again, relevant being to me that there is just, could be different work ongoing because of the two different units being on different timelines.
Okay, thank you. So, next on page 9, and again, I'm going to be listing the page numbers at the bottom of the page. In section 6.8, there's been a revision to the effect that each owner will be responsible for 50% of all decommissioning costs. The previous version, that section only applied to in the event of an early retirement event. Would this section require Kentucky Power to pay for 50% of decommissioning of ELG equipment it didn't use, is my question.
The ELG equipment it didn't use, it certainly would not do that because what we have added in here is each owner shall be responsible unless a different allocation is expressly specified as agreed by the owners in line 3 there. So, or as the owners mutually agree. In other words, when we added that phrase at the bottom of the paragraph, including in connection with the unit interest swap, it recognizes that under that swap, Kentucky Power may just retire its unit and not use the ELG. Therefore, that would be a situation where the owners would agree on a different allocation of the decommissioning.
On page 11, this is section 7.20, the operating committee's authority is expanded. Some lines have been added. Decisions not reserved hereunder to the individual owners regarding any buyout transaction or unit swap transaction are now included in the authority of the operating committee. Why is that change necessary?
Yeah, again, it's going back to the fact that the operating committee in this 7.2 has all these different responsibilities. And now it's taking on some additional responsibilities that perhaps the individual owners may have had before. If they do a buyout transaction and unit interest swap, we are giving more responsibilities to the operating committee. And so if the owners decide, the operator, which again with this agreement goes to Wheeling, you can make those decisions, but it is possible that now the operating committee will make additional decisions that Wheeling would have made before.
All right, so can you turn to page 14, and I'm going to focus on section 8.2. Can you read that one for me?
8.2 says, subject to FERC approval or acceptance of any termination, if necessary, this agreement shall remain in force until the earlier of A, the date on which this agreement is terminated by mutual agreement of the owners, including in connection with any unit swap transaction, or B, the consummation of a buyout transaction, the period from effective date through such date of the term.
Okay. So my question related to this is, if Kentucky Power changes hands and the new owner is unhappy with the bargain that's been struck in this agreement, can they not, force a renegotiation of this agreement?
Again, I don't have the agreement memorized. I think we have portions of this agreement would allow renegotiation really at any point in time. Not, and again, if part of the point here is whether the term could be changed, I believe that, really you have that capability at any point in time to renegotiate.
Okay. But in order to change this agreement formally, you would need the mutual agreement of both parties, correct?
That's correct.
So now I'm on page 16, section 9.6. Some green language has been added. The owner shall cooperate in good faith to negotiate and execute. My question related to that, are you with me, first of all?
Yes.
Okay. Does that mean that if the owners do not agree on a price and agree to the buyout, they're not acting in good faith?
No, again, I'm not a lawyer, but I think, again, it's just trying to ensure that the parties will work hard to get an agreement here, right? We all know that these can be complex transactions, and so it's just trying to make sure everyone works to the best of their ability, in Steve's words, not legal language, to do this.
Okay, thank you. I guess my last questions related to this walkthrough of the revised marked up agreement relate to the arbitration dispute provisions on section 12.4, that's page 21. So disputes related to the unit swap are to be decided by an arbitrator under binding arbitration, correct?
That's correct.
Okay. So in that section A of that section, some reference is made that the binding arbitration will be in accordance with the American Arbitration Association's commercial arbitration rules. Are those rules incorporated into this docket in any way?
I'm not an attorney, but I don't really think we're incorporating the rules. I presume those rules can change.
Well, that's kind of my point. The commission's going to be approving this document, so they need, in my opinion, they should be familiar with what those rules are, and as much as they're incorporated into the operation of this agreement. So if those haven't been incorporated into this docket, can we ask a post-hearing data request that at least the current version of those rules be included? Would that be okay?
I kind of would like to look to my counsel for
Okay.
help on this one.
Yes, I mean, I'll say, those are not rules we have in our possession. They're the AAA rules.
Right.
It's a pretty standard commercial arbitration provision that people reference, and that those, as Mr. Haynes said, those change over time. So I don't know if I could sit here today and say we can get those. I assume that they're public, and if they are, we can provide them to you.
That would be what I would be asking.
Okay.
If they're not public, Mr. Crespo, we have a bigger problem. If we're expected to approve or frankly disapprove or rule on this, and it may be read to tie this commission and West Virginia's commission's hands in the way they can approve or disapprove of a course of action, I think it would be important if you would provide that in response to today's request.
Yes, Your Honor. I just, not being as much involved in commercial litigation, I don't know how one accesses those rules at the time they're required to enter into arbitration. But I certainly recognize your concern, and we'll do our best to answer the question if it's asked.
Okay.
I think they're just available on the AAA website. So we should
Thank
be,
you.
someone should be able to get them and just download them in a PDF.
thank you. So I will follow up with post-hearing data requests on that.
Okay.
So at the top of page 22 of the document, it says, judgment on the award rendered by such arbitration shall be final and binding upon the owners and not subject to appeal or review, and such judgment may be entered in any court having jurisdiction thereof. So my question is, does this provision mean that if an arbitrator required division of the units in a way that the Kentucky Commission did not agree with, the commission would have no authority to impact the arbitrator's decision?
Yeah, the intent here was to have the owners work together and get a binding answer and say, here's your answer, but it wasn't saying, now you don't have to go through the regulatory process. The intent was, now you have your answer, now go through for the regulatory approvals, if anything changes from the prior arrangement that needs approved. So absolutely, and whether it be a single issue that's being arbitrated or the whole agreement, the intent is then it needs to come before this commission and the West Virginia Commission for approvals.
Okay. So near the bottom, kind of buried in that paragraph labeled B, still on the same page 22, I'll read from it. The arbitrator shall allow for each owner to receive an allocation of property and rights that the arbitrator deems to be fair and reasonable on an economic basis after giving due consideration to any regulatory requirements applicable to each owner, and 2, be required to select the proposal or package of proposals, as the case may be, of one of the owners, and shall not be able to select any other proposal except to the extent mutually agreed by the owners. So 2 questions related to that. What is the intended effect of after giving due consideration to any regulatory requirements applicable to each owner?
Well, again, having not been through an arbitration to this degree, but again, I believe each owner is going to come in with, here are the, and as it notices, that you have a proposal, so you have to stick to a proposal. In that proposal, you have reasons for that proposal, which may include, in Kentucky Power's case, here's what my commission is requiring of me, and that's why I need this in this transaction. Wheeling may say, here's what my commission is requiring of me, and that's why I need this much. So that, I believe, would say that. Of course, there could be also other environmental, there could be, but the point is that you're able in your proposal to state, here's why, including regulatory requirements for why my proposal is what it is.
Okay. And I think, my second question, I think you alluded to it, but the arbitration is set up in a way that both parties, in this case it'd be Wheeling Power and Kentucky Power, would come in with a position, and the arbitrator would have to pick one or the other, correct? They
That's
couldn't
correct.
Split the difference, okay. So, you referenced the West Virginia Commission. I think yesterday, or maybe it was the day before, and it might have been with your testimony, I think someone brought up the fact that there's a parallel process going on in West Virginia, correct?
Yes,
Okay, and there's an upcoming hearing.
yes, April 7th.
Okay, has this revised ownership agreement that includes the alternate unit swap language been presented to the West Virginia Commission for approval as well?
I believe it has been filed at the West Virginia Commission, yes.
Okay, so can you just talk about the risk of inconsistent decisions from the 2 commissions and what would happen if that were to play out?
I think, I don't have a lot of understanding of what the possibilities, I understand what the possibilities might be. I don't know if I can answer exactly how it will play out, but they are on still a parallel path, as you know, where rebuttal is being filed this coming Monday, hearing April 7th. And so they're close to the same timeline as this proceeding. And to your point, could there be some different requests being made of revisions in the document versus revisions that may be requested by this commission? And that is a possibility. And I have to admit, I almost need, again, council help on how we would resolve that. But we have been in also discussions there with different parties, working through both an understanding of this agreement, similar to the questions you're asking here, as well as working on a consensus around the agreement. So we're making progress there, but I don't really know what the likelihood is of a difference in opinion between the two commissions.
Okay. Just one more line of questions. Kind of relates to the timeline for how this process is played out in the presentation of these operating and ownership agreements to this commission. We heard yesterday that the approval of these agreements are conditioned precedent to the closing of the transfer, correct?
Yes.
Okay. Was it Liberty or AEP that insisted on making that a condition precedent?
Well, as we've noted in filing this, AEP is realizing that both Wheeling Power and Kentucky Power need these agreements approved regardless of a transaction. So there's an urgency on AEP's part, which I, in the other case laid out yesterday around the operator, the ELG construction, as well as cost allocation and then disposition. Liberty, I don't recall who asked for it first, to be perfectly honest with you, but Liberty did request that it be a condition precedent. Was it AEP first or Liberty first? I don't recall, but certainly it was a part of the negotiation, and it was agreed to.
Okay. And it ended up in, as a condition precedent, in which agreement?
It's in the stock purchase agreement.
Okay. And when was that stock purchase agreement entered into by the parties?
October 26th, 2021, and it's filed in this case.
Okay. And when was the transfer application filed?
The transfer application was filed in early January, but I don't recall the
January
exact
4th?
date. Was it
Does
the
that sound
4th?
right?
Was it January 4th?
Yeah, I
Okay.
believe that's correct. I guess my question is, if the approval of the Mitchell agreements were so important to be made a condition precedent, why didn't the parties just wait until those agreements were approved before filing the transfer application?
Well, again, there's a lot that has to happen in getting the stock transaction approved, and also, I'll just say that everybody had made commitments in that stock transaction, as was noted to, I think, witness Eichler in the other case. By October, we really are trying to, certainly have the transaction closed, and there's a lot to get done. So I think from a timing perspective, it was optimal to try to work in parallel. I know that makes it challenging for all parties, but there's a lot to get done in a transaction, and this is just one of those things. And so, again, as much as we could file, and I'll say in a near parallel basis, we did.
Was AEP aware that once the transfer application was filed, the commission would have a deadline by which it would be required to issue a ruling?
On the transfer case, yes, but not necessarily in these agreements. These agreements has no specific deadline. We just, again, for both commissions, both Wheeling in its filing and Kentucky in its filing, both requested an urgency because of the matters I mentioned a minute ago.
Well, can I ask Mr. West, but that's all true, but also these other agreements, you stated in your testimony in the last 2 days that approval of these agreements are conditioned precedent to the transfer of control, and although we have to approve a case or it automatically gets approved under 278-0207 within 120 days, the things that are not pressing or don't have a statutory date, by your own testimony, are conditioned precedents to closing the thing that does relate to the statutory date. I mean, is that unfair to
that's
say?
true. We would not be able to close without these agreements being approved and being able to execute the agreements. And so, as has been noted, we have to file it FERC after the approval of this commission in West Virginia. So timing does matter. So again, I do not want to say, don't want to say there's a deadline when there's not, so.
Sorry, Mr. West.
No, but as the chairman took my last question, that's it for me.
All right.
Well, that's not the world's worst thing. All right. It's 12:10, so we'll keep pushing on. And we weren't on the record when we spoke earlier, but I think the intention for anybody for the last time I looked, the 48 people that are watching this remotely, I don't know, they should have something better to do, but they don't. They're watching this remotely. For the 48 people that are watching this remotely, we're going to push through at least till about 1 or 1:15 to see if we can finish by then, and if not, then we'll discuss what we should do for the remainder of the day and whether to take a break. So, Mr. Kurtz, do you have any questions for Mr. Haynes?
I do, thank you, Chairman. Good morning, Mr. Haynes.
Good morning.
I mean, I think we all understand that AEP is kind of in the middle with a split decision on the ELG, and you're trying to kind of broker a deal between West Virginia and Kentucky and Liberty. So I just want to ask you some background. What does West Virginia want out of this transaction?
Well, I've not been directly involved in the discussions, but I've seen the West Virginia orders, and it appears West Virginia does want the option to be able to continue to run a unit or all of Mitchell plant post-2028, and that's clearly in mind.
And the two commissioners will decide what Kentucky wants, but what is, in terms of trying to broker this deal, what is your understanding of what Kentucky wants?
Well, based on the orders again given, it seems Kentucky is saying not to pay for LG, which currently would mean, unless something changes, not to run its share of the plant past 2028. But it clearly, based on feedback we've gotten, that people still want to have flexibility around how they get to that endpoint, which I suppose could change into running a unit. But to date, the message is that its share of the plant, whether that be a unit or undivided interest, somehow is not going to be operating post-2028, or I'll say not in Kentucky's hands post-2028.
Why does Liberty want certainty, in your understanding, regarding Mitchell before closing on the acquisition of Kentucky Power?
Certainty around approval of the agreements.
Why do they want certainty around Mitchell before closing on the purchase of Kentucky Power?
I think that's a question better asked of them.
I get it, but they're not here. What is your understanding of
I think
what?
the witness Eichler laid out that they're looking at a number of things. They clearly, it was mentioned that they would be looking at renewables and other capacity options for Kentucky Power, but that would still be determined based on what happens with Mitchell, whether and how much they're able to do. So the point is, the sooner you have certainty about things, the better you can plan, and the better you can, make decisions.
I mean, that's understandable. Mitchell is 780 megawatts. The Kentucky Power load's about 1,100 megawatts. If you're going to own a utility, you kind of need to plan and have certainty about. It's easier to plan the system, would it not, if you knew that on 12/31/28 you need to replace it versus this ongoing question.
That's right.
So, and what this alternate proposal, which we supported submitting, it kind of just seems like it's going to perpetuate the litigation that we're in. Everything is kicked over to the operating committee, which is kicked over to arbitration, which, I mean, it seems like it's a recipe for just endless controversy of the type we're dealing with here, rather than resolution. I'll put it in a question. Do you see that perspective?
I mean, that's one perspective. Another perspective is that Kentucky Power and Wheeling both have potentially different interests. They may have the same interest as they work through it, but this would give them all the options to work through those options and see how the interests are aligned or misaligned, and then make decisions and then come to an agreement. Because remember, everybody focuses on the unit interest swap, but first you could still do a buyout transaction, you could still do a retirement, or you can do the swap. Again, so both parties can get what they're looking for, and this allows, again, it allows that all to happen.
We've opposed the Liberty transaction, but if the commission says Liberty transaction is in the public interest with or without additional conditions, would it seem to be a bad policy that decision would then be voided by the fact that Mitchell is not resolved? You see, so I mean, if Liberty buying Kentucky Power is in the public interest, isn't it sort of the bad policy if that public interest betterment terminates because we don't have any resolution around Mitchell? I guess what I'm saying is, let me answer that question.
Well, even though I said a minute ago that sooner is better on Mitchell, there is still time to make that decision, and there would be time, and this agreement gives you the flexibility for both parties to, I'll say, get an outcome they're looking for, and so there's time to do that. So I don't believe it leaves too much uncertainty. It leaves the options and ability. I believe Kentucky Power will be filing an IRP in December, and it has that ability in that filing to lay out a lot of what it's looking for, including analysis around Mitchell.
Right, and that IRP would be more certain if you knew for sure that there was not going to be Mitchell after 2028 versus
But you would need analysis to determine whether that was the case. And again, the IRP could provide that analysis.
Man, is West Virginia okay with the new decommissioning where it's either upfront or Kentucky pays when it's actually incurred?
I have no knowledge specifically. I've not been in any of the West Virginia discussions.
Both Kentucky and West Virginia have opposed FERC jurisdiction over the ownership agreement under the legal premise that there is no jurisdiction by FERC over generating facilities under the Federal Power Act, because this is not wholesale sale in interstate commerce. It's something different. Is that your understanding?
I'm not recalling the rationale for the filing. I just know we withdrew our FERC application until we get the commission approval.
Do you have any detailed knowledge, of the size of the load of Wheeling Power?
I don't recall the specifics there.
About 4.5 million megawatt hours a year retail load. Do you have any understanding of the megawatt hours that Mitchell would generate at various capacity factors?
I'm forgetting that. Sorry, I know I've seen it in the past, but I don't recall.
Let me ask you if you've considered a different, simpler, sort of a self-policing type approach, if this makes any sense. I'm going to hit you cold with it like everybody else. What if the transaction was that after 2028, Kentucky Power got a share of any off-system sales profits made by the Mitchell plant? So it either got a check every month from West Virginia or didn't pay anything. There would be planning certainty that the unit would retire from Kentucky's point of view. If West Virginia continued to operate it, that Kentucky would just share in profits from off-system sales.
It's an interesting proposal, and what I would say is this agreement has a buyout transaction where that could be structured in, but again, it would be both Kentucky Power and Wheeling working together to determine if that would make sense as part of a transaction.
I say it would be self-policing because both utilities would be in the same boat. If West Virginia would want to make profits from off-system sales, if they did, Kentucky would benefit. If the unit doesn't dispatch, well, it would be zero, but it would be no further liability for Kentucky.
I can see the potential benefits, but again, can't comment specifically. Again, I believe there's time and opportunity with the structure of this agreement to do something like that.
Okay, thank you, Mr. Haynes.
Thank you.
Ms. Wenzel?
Thank you. We've got a few questions. Good morning, Mr. Haynes.
Oh, we're in afternoon now. Good afternoon.
Good grief we are. Thank you very much. I'm going to refer to something from yesterday's hearing. I believe it was either a direct or a redirect with you and Mr. Crespo. Mr. Crespo offered up and you responded that the Mitchell ownership agreement and the operation and maintenance agreement basically map out exactly what's in the current operating agreement. So I'm going to put this out. As a post-hearing data request, I would like for Kentucky Power to provide a cross-reference starting with the current Mitchell agreement and providing cross-references to each of the articles to where they are in the ownership agreement and the operating and maintenance agreement. There are a significant number of provisions that are not in the current agreement, and I think it would be helpful just to look at that mapping.
Right, that's what I was going to say. There are obviously, as I mentioned yesterday, So I'll put it on the record here that it is now an arm's length agreement that allows for non-affiliates. So there are a lot of provisions, to your point, that are not in the current agreement. So we could map what's there today, and then I'll say everything else is new essentially, if that makes sense.
And I'm sorry, you're saying right now that the proposed agreements are arm's length agreements?
They would work for, again, non-affiliates as well as affiliates. In other words, it has credit provisions, other provisions that are not in the operating agreement, which was done when those were two affiliate companies.
Let me ask for clarification on that. Ms. Vincent. So, you're not saying they were negotiated at arm's length. You're saying they're written in such a way that they apply now to people who can be or cannot be affiliates. Is that
Yeah,
fair?
that's what I meant. Sorry if I misled you there. But yes, it's allowing for two parties to be at arm's length so that it could be provisions for any difficult times, because affiliates will work it out because they're affiliates. But if they're not affiliates, they need these provisions.
Okay, thank you.
Thank you. And I want to go back to clarify something that Mr. West asked you about. I think this comes up a couple different times, but in particular regard to the arbitration provisions in Article 12. And you say that the intent is that any decision by the arbitrator would come to the Kentucky Public Service Commission and the West Virginia Public Service Commission. But that is not included in the language of the agreement, is it?
No, it's not.
And I recognize you're not a lawyer, and I'm not going to ask you for a legal opinion, but I would point out that there is a generally accepted contractor term of a four corners rule, where you can't, if the parties have agreed to something and put it in writing, that you can't imply or infer a meaning that contradicts the terms. So my question is, if it was the intent, why is it that not in the dispute resolution?
Yeah, again, not having memorized the agreement, I thought there was something in here that allows us what I'll call the broad statement that says things that happen in this agreement, if they need regulatory approvals, you'll seek it, but I can't point you to what section that's in. So if you need to ask, we could find that for you.
Well, I hate to do a walkthrough, but I'm going to.
Oh, okay.
Except I'm going to start backwards. Let me find. I want to look for, in Article 12, it's 12.6, and I'll get the page number here.
23.
Thank you. On page 23, tell me when you're there.
I'm there.
In 12.6, what it says here is that nothing in this agreement is construed to preclude either owner from filing a petition or complaint with FERC and so forth, going through. So it's giving FERC jurisdiction over this agreement. Is that the section you're thinking of?
No, and I'm not recalling why specifically that provision was in there. I will note that that provision was in there before this revision to the agreement for the unit interest swap. So but that's not the provision I was thinking of. I thought we had it somewhere else where, again, you need to.
I don't want to testify for the witness, but are you thinking about 13.2 on the next page?
Oh, thank you. Yeah, so, because again, that we're not trying to bypass regulatory requirements with this agreement. We're really trying to focus on the actions between the two owners and making sure both owners are being taken care of and that there's clarity in the process. But then, thank you for that 13.2 saying, we still have to follow the rules of each regulatory body that we're under the jurisdiction of.
Okay, thank you. I have a question about the proposed timeline.
Okay.
And it's in regards to, let's say we get to that point and there's a unit swap.
Yes.
So there are two key regulatory decisions that would be before this commission. I'm going to ignore any other commission.
Okay.
No disrespect to them.
Okay.
So we've got approval of the unit swap
Right?
that needs to occur. And then we're going to have a approval of a CPCN for Kentucky Power to operate Mitchell going forward. A decision's already been made in case 2104, I'm going to use the shortcut, that the ELG project was not economic and that Kentucky ratepayers aren't going to pay for it. So if there is a decision and there is any thought of moving forward with the unit swap and the Mitchell unit that went to Kentucky would not be retired. That's my scenario. There would have to be express approval from the commission to operate the unit, given that there is ELG, and there's going to be a question of payment. So that's my backdrop to this question. Let's say it's only a question of approval of the unit swap. Under the timeline, it sounds like there has to be a decision in place by May 1st, let's say. I know it's early May. And negotiations don't start until January 1st. That results in a very limited amount of time for a review. Would you agree with me?
Yes, I would agree with you. I think the parties in reality are going to have to, kind of what we often do, and when we have to get regulatory approvals and work backwards for what they really need to do to come to a transaction and get the regulatory approvals in time for being able to notify PJM. So I think that is a very tight timeline, and you in reality probably would, again, those are what I call the drop dead deadlines, but you really need to be in reality working sooner than that. And as I mentioned, Kentucky Power, for example, filed an IRP, and then it will be going through that IRP process, and that may help it decide, okay, this is what we want to do now, and start working with Wheeling well in advance of that drop dead date on all right, we either want a buyout or a retirement or a swap.
I guess, again, my larger point is that the agreement as written doesn't allow for the type of regulatory approval timeline that would be necessary to move forward with the unit swap.
It's correct. There's not a specific regulatory timeline built into the dates.
Okay, thank you. Mr. Haynes, are you aware whether there is an ownership and agreement that was executed for the Sporn plant?
As Mr. Kearns referenced, I believe there was some form of agreement, but I don't know what form it was in, whether it was an ownership or an O&M agreement or operating agreement, but I believe there was some form, but I don't know, again, what form exactly it took.
I think what I will do is just ask as a post-hearing data request for a copy of whatever agreement there was between the two entities, but also for Sporn and for the Cardinal plant.
Okay. Yeah, we just have to be mindful of confidentiality around the Cardinal plant, but we still we'll see if we can do that.
I appreciate the caution, and yes, it definitely would be filed under confidential protection.
Okay.
And I know that your counsel know how to do that very
Yeah.
well. Can I have you turn, okay, I wish I was efficient as Mr. West and just did page numbers too. In 9.6A, and I will get that page number, it is page 16.
Yes, I have it.
This is a good example here where it states that the unit swap is subject to applicable regulatory approvals, but doesn't list who the regulatory approvals are. Again, this is, we talked about certainty and the need for certainty. Is there a reason why particular jurisdictions such as the Kentucky Public Service Commission, the West Virginia Public Service Commission, were not named expressly without limiting just to those approvals?
Well, to limit those, again, as I mentioned a moment ago, this is allowed to be owned. This agreement could be a different owner in future years. In other words, Kentucky or Wheeling could sell its share of the plant, and then that company may have even additional jurisdictions. So certainly wouldn't want to limit the jurisdictions. Certainly we could have named the jurisdictions. As was noted in 13.2, we're going to make sure we satisfy all the jurisdictions that the plant is being regulated by, or that the owners are being regulated by.
And I would agree with you, you would not want a limiting term. That would be very, very poor drafting just to limit, given that possibility. But also excluding the name of known regulatory approvals now also creates some open questions for contract interpretation down the line. And again, you're not a lawyer, I'm not asking you to do contract interpretation. I'm just was wondering what the intent was, to the degree that you can speak and provide a lay opinion.
Again, I think we're trying to be as succinct as possible, but still recognize that the owners need to know where they need to determine where they need to go seek regulatory approvals for any transaction that's mentioned here.
I just have one last question, and this is about Article 6.9. Which is on page 9.
Okay?
Tell me when you're there.
I'm good.
Okay. And in this provision, it basically says that any obligation to pay under this agreement cannot be conditioned upon or affected by a regulatory order disallowing, limiting, modifying any payments. So that then leaves an open question, is Kentucky Power Plant, how will Kentucky Power treat an expense that the commission expressly disallowed?
Then Kentucky Power would be passing that through to its shareholders, right, if that cost is not approved. So really the idea here is that the two owners agree, we're going to be making that investment or that operations expense or whatever. The commission can still rule as it should be, as the prudence, but the owners will not say, oh, it wasn't approved, you don't have to pay it. You still have to pay it to the other owner, your 50% share, or if it's something else that's a different allocation, the appropriate share. But the regulatory approval doesn't dictate whether you pay your co-owner your share of the cost. But then the shareholders may be bearing that cost.
Okay, I just wanted to make sure that we got that in the record.
Okay.
Staff has nothing further.
Yeah, I have a few questions. Good morning, good afternoon.
Afternoon.
I keep forgetting. I just want to take a step back, and I know it's been stated, I can't remember if it was you or someone else, and whether it was the past 2 days or the beginning of the month, because things are starting to run together, that the need for these documents was precipitated by the conflicting West Virginia and Kentucky orders, and specifically our order directing changes to the agreements.
Yes, but and then the West Virginia order subsequent, and then in October, of course, orders that said move quickly to provide updated agreements and to make Wheeling the operator.
And I'm glad you said make Wheeling the operator. Couldn't this have all just been dealt with by changing the existing operating agreement to make Wheeling the operator? Wouldn't that have just been more simple, or is some of this also being driven by the transaction that's been proposed?
Just making Wheeling the operator would not have solved the cost allocation issue, the capital investment allocations that, for someone who wants to run the plant longer, as well as the disposition issue. So could all these provisions have been, I'll say, added to the operating agreement? That could have been done, but the point is that we don't believe that just making Wheeling the operator would have been sufficient.
Okay. Given that the approval of some form of these agreements is a condition precedent to closing the Liberty transaction,
Right.
aren't we in a situation where we have to approve this and treat it as an affiliate transaction? Because it's going to have to be approved before these wouldn't be affiliates.
That's under the current state, that would be an affiliate transaction, and what we hope we've drafted here is something that the parties and the commission would agree is something that makes sense if the companies are affiliates, or if the Liberty transaction closes and they're not affiliates. So I mean, that's the intent here, is that these provisions work in any event. But it appears to be an affiliate transaction.
Okay. And what we are being asked to approve now is this new form of agreement that's got the unit swap. The other's completely off the table and not as an alternative?
That is the proposal. We, in my supplemental testimony, made it clear that we got the objections in both states to the buyout transaction with the fair market value. So
That's gone.
So the exhibits S1 and S2, really S1 with the clean version, is the proposed in both states.
Okay. Just wanted to make sure I was clear.
Yes, thank you for asking that.
On the timing, and this may be a really ignorant question, I hope it's not. On the timing by the May 1st, 2025 trigger because of the PJM planning,
Yes.
would that be affected at all if the Liberty transaction closes and in a couple of years Liberty tries to leave PJM?
One of the interesting things is that Mitchell is in PJM no matter what. And so I don't believe that changes this decision. In other words, there could be some change in costs or other things that I'm not very familiar with around how you move the power from Mitchell to that Kentucky zone if it moved out of PJM. But Mitchell is in PJM and should not change that.
Okay, so that date's going to stay the same regardless of Liberty's
It stays the
decisions.
same, that May 1, 2025 stays the
Well,
same.
if
and
PJM's
will change
planning
its
year
dates
doesn't
as it
move.
changes its dates.
Right. Okay. And that was what I thought the answer was, but I just wanted to make sure I understood. Let's go back to, and this is really my last couple of questions, and they're really rinky-dink questions about the arbitration provision. And you may not know the intent behind these, but I know Mr. West mentioned the AAA rules that are essentially incorporated by reference. Is it intended to be the AAA rules in existence as of the time of the execution of the agreement or as of the time of any potential arbitration? And you may not know. That may be
Well, I
a really
think-
lawyer question.
Yeah, but I believe as you read it, it's at the time of the arbitration, because it really is an arbitration administered by American Arbitration Association for resolution on expedited basis, and it would be the rules at the time, really, because that's when it occurs.
Okay. And then I just want to clarify on page 22, where we're at the bottom of subparagraph B, and I believe Mr. West also brought this issue up, the arbitrator is being asked to pick a proposal, essentially. The arbitrator can't go off on his or her own and, like, split the baby. Is that right?
That's correct.
What's the reasoning there for limiting the arbitrator's discretion?
Well, part of it is to Mr. West's other question here. I think it was his question around the regulatory aspects of each one has their own interests in creating the proposal. And so I think part of it is the arbitrator goes in a different direction. They may choose something that either one or both states may not like in terms of the two owners. So we really need to say, create a proposal that you know would get approved by your regulator, and that's what the arbitrator should be sticking to.
What if the only sticking point is literally like by price, like a cost? I mean, then the arbitrator's got to pick either the high or low. They can't.
That is possible, because we have structured this so it could be a single issue, which obviously makes it an easier arbitration, but to your point, could end up with a very different answer.
Okay. And this is my last question. Is there, if we end up in a unit swap down the road, we've gone through everything and we get, that's the fallback, and we end up in a unit swap, is there anything in here that would put a limitation on Kentucky Power then selling its unit to a third party?
The only limitation, as noted in my testimony, is that because Wheeling made the ELG investment, you need really to work out to the satisfaction of the buying party who buys the interest, that they can have an arrangement to have access to those ELG facilities.
Okay,
So you
but-
have to work that out.
But Kentucky Power isn't restricted. They don't have to either become the operator or close it down. They could sell it to a third
They
party
could
if the
sell it to
third
a
party
third party,
wanted to
but
work
the
out
third party
with
has to be
Wheeling.
aware that they need to make that arrangement.
Right, okay. That's That's it. Thank you.
Thank you.
Mr. Haynes, are you participating in the same or similar manner in the West Virginia proceedings as you are here in Kentucky?
At this point, I'm not participating. I may end up participating, but to date, I'm not.
You all have, and I say you all, someone within the AEP family has rebuttal testimony due on the 4th in West Virginia. Is that your understanding?
Yes.
Or do you intend on providing that rebuttal testimony?
At this point, I've not been asked to.
Have you read the testimony of the staff there in the West Virginia Commission?
I've only skimmed it.
So that's more than what I've done. I've just seen a news story written about it. But it was filed on Monday. Is that your understanding?
Yes.
Following your skim, what was the position of the testimony as a general matter?
It seems like they're asking for some significant changes and that some things are not in the interest of Wheeling, it appears.
Anything in particular, or anything that's been discussed today during the hearing? Well, here's why I asked. We're in this weird position where we thought we were doing a good thing by requesting 10-day status updates on everything going on in West Virginia. But Monday was one of the days as the 10-day update, but Monday was also the day by 4 o'clock that the testimony had to be filed. So it wasn't included in the 10-day update. And so we don't, it would be convenient, I think, for the purposes of the hearing today to maybe, a lot of the problems, if they're going to be considered problems, are the fact that there are two parallel processes dealing with the exact same thing. Would you agree?
Yes.
Yeah. And that there's obviously going to be a lag between when we make a decision or when somebody files something in this case and then West Virginia makes a decision and files something in that case, that the ability to take it into account at the other jurisdiction does create at least if nothing else, a timing conflict. Is that fair?
Yes.
So the Kentucky Power requested a CPCN, two CPCNs from this commission, the first for ELG and the other for CCR. Is that your understanding?
Yes.
And the commission only granted one of those CPCNs, is that right?
Just the CCR.
CCR. So the CCR is related to the ash pond and the ELG is related to the, changing the way the plant operates so that it doesn't use water to, well, let's say it limits the effluent, it's the effluent limit guidelines rule, right?
That's right. So it has dewatering equipment and other ways to manage the water.
Dry ash handling instead of using water, which then sluices into a pond. Is that a fair characterization?
Yes, that's an overview of it.
So, 2028, this 2028 date is not a date in which it's perceived that the Mitchell plant is no longer economic. Is that fair?
The 2028 came about because of the dates in the guidelines, which said if you don't do this, by this date you shall shut down. And so, again, deciding not to spend the investment in the ELG and only doing CCR meant that was the date. But it does not mean it's necessarily not economic, but you have to be able to ensure you're meeting all the environmental rules.
So 2028 is not a function of any analysis anybody did. It's a function of the EPA rules. Is that fair?
That drove the date, yes.
December 31st, 2028, that if you wanted to operate past that date, you had to start in your endeavor to become compliant with ELG by, I think it was maybe a 2023 date. Is that accurate?
Yeah, I recall a 2023 date. Again, I'm not an expert on the exact rules, but that I do recall that date.
So that, other than that, and that being that December 31st, 2028 date being related to that EPA rule, is that date implicated in any other, are you aware of any other significance for that date that drives this conversation or these documents?
No, that is the primary driver.
Okay. And the West Virginia Commission has approved Wheeling Power the CPCN necessary to make both Mitchell Unit 1 and Unit 2 ELG compliant, correct?
Yes.
Okay. And have you read the order in case number 2021-00004 denying the CPCN for ELG?
At one point, I have read it before.
And reading it, did you take the commission's order to say, no, that's not economic, don't do ELG, or that the company failed to meet their burden of proof that they should get a CPCN for ELG?
I'm not really in a position to interpret and that nuance, which seems legal, so I can't really say.
And that's fair, but it was that denial of the CPCN that drove the significance of the December 31st, 2028. We do agree with that, right?
Yeah, between the two states' orders, it drove the significance of that date.
Well, and the reason I ask that is because obviously this 2028 date is front and center in these agreements. But this unit swap would seem to require just a cursory review. I'm not saying it does, but it might be argued that that would require, in order to change the ownership and effectively purchase a single unit as opposed to having a 50% undivided interest in two units, would drive a certificate of public convenience and necessity of itself.
And again, I just can't.
And that was less of a question. Sorry, I paused, paused for effect, as somebody said yesterday. So, if that requires a CPCN, you're aware generally of the CPCN standards. You've read the 2021 00004 case. You've got to prove need and an absence of wasteful duplication. But that's what the unit swap, the backstop in this ownership agreement, would seem to require. If it did require CPCN, you'd have to come back in and go through that entire process again. Is that fair?
That's the impression I'm getting, and Ms. Vinsel has also mentioned that same thing, so that does seem to make sense.
And I can appreciate maybe the interest. It's cleaner, certainly, than this. You get an appraiser, and I get an appraiser, and then they go find an appraiser, and then we all appraise, and then we show back up to the commission saying we've come up with a number. The unit swap would at least seem to be cleaner in that you just, take a knife and you split it right down in half. But the reality would be that even if if the unit swap was implicated and Kentucky Power came back to the commission, it would be in effect requesting a CPCN for a unit that is ELG compliant, that built ELG,
Right.
after the commission had already found that the company didn't meet the burden of proof that that exact unit should have ELG built. Does that seem odd to you?
Again, I want to remind that the options under the unit interest swap include still retiring your unit, and I would presume in that case you would not need the CPCN. So under the other options of running, I would think you would need a CPCN.
And maybe I missed it in the agreement, but if the unit swap occurs and immediately retired, is Kentucky Power on the hook for the ELG costs for the undepreciated value?
No, there's nothing there that says they have to pay the ELG costs if they're retiring their unit. As that Exhibit C says, you're going to work out your costs for anything that needs to be done around the common facilities, including ELG. So that's a retiring of your unit. Obviously, you're not using the ELG post that date, so you wouldn't be having to pay for that.
How does that make sense? So Wheeling is going to pay millions of dollars to make both of the units compliant with ELG when the backstop under this ownership agreement is that in 2028, one of the units could just be retired. If that was the case, why build the ELG on one of those units?
Well, again, the ELG will be in effect and in operation earlier than 2028. It will be in operation for a number of years.
It will, but it's not necessary in order for that unit to operate through December 31st, 2028. Agreed?
And I will again go back to the options before you get to the unit inter-swap are a buyout. I mean, that is still an option for the two parties to work out a price and work out a buyout in which Wheeling would then be able to use all that investment on both units.
Okay. I'd like at this point to go into confidential session, if we could. Okay, so, if the arbitrator makes a decision, can't be appealed, both parties then go to their respective commissions, assuming it requires commission approval, whatever that decision was, and one of the commissions disagrees. It's not, yeah, it's happened before, right? It happens often. What then?
It does force you to go, I'll say, back to the negotiating table to, again, recall the approaches. There are multiple proposals, and you may have to go back to the arbitrator, say that proposal doesn't work, it wasn't approved, and now what are the other proposals on the table? And the two parties again talk and again, hopefully work it out, but if not, go back. But the idea would be whatever wasn't chosen, go back to one of those other options.
Do you think it should be clear, I'll do it this way, if the unit swap, backstop unit swap occurs, and the purpose of the swap is exclusively so that Kentucky Power can retire a unit, whichever unit it gets, do you think that let me ask it this way. Do you think that the EOG costs, any of the EOG properties should be part of that swap?
Whether I think it does or whether the agreement says that. I mean, the agreement.
I'm asking you right now, whether you think the ELG should go as part of that swap. If the swap is occurring exclusively so that Kentucky Power can retire the unit,
I mean,
should the
certainly-
ELG costs go with the unit to be immediately retired?
I mean, there's nothing that would be needed around the ELG to retire a unit, very obviously. So those costs would stay with those who are using that equipment would make the most sense.
Okay. But the agreement doesn't say that, right?
No, it allows the parties to work it out because, again, we're allowing the parties first to choose their option that they want to do with their unit and then work through the details.
So let me go back to the question that I think I asked you at the other hearing is, what's the point of this Mitchell operating agreement if it's not for certainty? And I was asking, why have this ownership agreement, right? What's the purpose that I think Vice Chair Cubbage and I are both trying to get to? Why do we need this ownership agreement? And your response is to provide certainty. And I can appreciate it's not the world's easiest thing to come up with a legal document that is applicable in all situations. But my question really underlies, if the purpose is to provide certainty, and there's at least some expectation, it's been part of this discussion from the beginning, that the unit swap could occur and that the Mitchell plant could be retired at the end of 2028, then why shouldn't there be certainty why shouldn't there be certainty around what the costs are going to look like if that happens?
Yeah, well, the certainty we've provided are certain paths to the two parties so that, I'll say, under unit swap, they can, I'll say, go different paths if they choose, rather than go one path, right? One retirement path or one owner owning both units. But this is really, the certainty is really around the paths and the options rather than saying, okay, I know exactly what this deal is going to look like in 2028. I think that's really what we've created.
If Wheeling is going to do the ELG compliance, they should pay for the ELG cost. Would you agree?
And they have already agreed to do so.
That's fair. Mr. Crespo, do you intend or have an expectation of calling Mr. Haynes back following Mr. Collins' testimony? Let me ask you this way. Would you be offended if I requested Mr. Haynes come back after Mr. Collins' testimony?
No, Your Honor. We don't have the present intention to do that. It would be based upon what Mr. Collins testifies to.
Okay. So that's all the questions that I have for Mr. Haynes at this point. But I'm just gonna go ahead and tell you, I would like for Mr. Haynes to stick around, because I would like to have an opportunity to recall him after, Mr. Collins.
Yes, Your Honor.
Do you have any redirect you that, like, well, let me ask this. I gave you this benefit the other day, and I think it's beneficial. We know we're gonna come back. So how would you feel about going ahead and taking a lunch right now? And giving you and Mr. Haynes an opportunity to maybe narrow your redirect however you would like? And then we can come back and let you conduct your redirect after lunch.
Yes, Your Honor, that would be helpful in making most efficient use of the time, I think. I was also going to ask you if Mr. Kearns is excused at this point, or would you like him to stick around also?
He
fine
can be
with that?
excused.
That'd be fine. We can excuse Mr. Kearns.
Yeah, thank you.
All right, so we will take we'll just take a 1 hour break until 2:20.
Yes, thank you.
What's that? Mr. Crespo, do you have any redirect of this witness?
Yes, I do. Thank you, Your Honor. Now, Mr. Haynes, today we've been discussing the alternative proposal described in your supplemental and rebuttal testimony.
Yes.
And we had a prior proposal to that, the original one, which involved the fair market value buyout. I'm sure you remember.
I do.
And can you just describe for the commission and the parties what was really the purpose of making the shift from the initial proposal for the buyout to the alternative that we have now?
Sure, the point of the buyout and with the unit interest swap proposals, they really are the backstop. So you still have these other options in front of you to either retire a plant or to work out a transaction to sell the whole plant to Wheeling Power. But we needed a backstop in case that failed. And in this case, the first proposal, it was the buyout at fair market value with appraisals. And now the option is to do an interest swap so that each party owns one unit. But again, as a backstop.
And Mr. Haynes, is there any change as between the first, I'll call the first option and the alternative option for the buyout related to whether or not Kentucky Power would be required to pay for ELG costs?
No, there's no requirement for that to know. We wanted to make sure this was compliant with all the orders from both states so far.
Yeah, and your understanding of those orders is what, as far as ELG cost goes?
My understanding is that West Virginia gave us whatever CPCN or CCN for Wheeling to construct the ELG and pay all the costs. And then this commission gave an order saying only do the CCR investment and not pay for any of the ELG investment.
Thank you, Mr. Haynes. And so it's, in other words, it's clear in your mind that Kentucky Power is not to pay for ELG costs under the current orders.
Under the current orders, and then this agreement is compliant with that.
Right. And that none of those costs are to be also, as a natural consequence of that, to be paid by by Kentucky customers.
Correct. It would not be passed on to Kentucky customers.
And is there, and as you understand it, is there any way that Wheeling Power could unilaterally cause Kentucky Power to have to pay for ELG costs?
Not only, there's nothing in here that would unilaterally require Kentucky to pay for it, but also not to pass it on to customers, right? So you really have both of those. Kentucky should never have to, Wheeling does not have a unilateral right to pass on the cost to Kentucky Power, and obviously Kentucky does not have the right to just pass it on to customers.
And that's expressed in the ownership agreement in the provisions related to the division of the initial construction costs and the operating costs for ELG.
Right, where the costs are 50-50, except for costs where one owner has decided to bear all those costs, such as ELG.
Right. So Kentucky Power doesn't have to pay for ELG costs there.
Correct.
And it also does not have to pay for ELG costs under either the original buyout provision or the alternative buyout provision.
Is not required to buy out at any of the alternatives with the swap, particularly if it decides to retire the unit.
And Wheeling Power cannot require that either under either the current buyout provision or the alternative either.
Correct.
Okay. And is there any circumstance under which Kentucky Power might elect to pay for ELG costs?
Again, as we proposed as an additional option under the unit interest swap proposal, is if the swap occurs, Kentucky owns one of the units, and it decides to continue to operate the unit, that would be the only situation where we could see any ELG costs being passed to Kentucky. But again, it would need to come to this commission for approval.
And even in that circumstance, it wouldn't be Wheeling Power's unilateral right basically to shift ELG costs to Kentucky Power?
No, it would not.
has to be a mutual agreement.
No, it would be an agreement of both parties.
And that's only under the scenario that Kentucky Power wants to continue to operate.
Correct.
And sitting here today, we don't know if it'll want to make that election.
No, we don't know the answer to how the options will be played out.
And as you said, even if it did, if it was going to deviate from the orders of this commission, it would have to come back to this commission.
Yes, it would.
And so, just the overall characterization of the alternative, would you say was intended to be more beneficial than the, how did we get here? What we were really intending to do with it?
Yeah, really what the buyout Willie was just one option as the backstop, which is Wheeling buys everything. Wheeling would have the option to operate the plant to whatever length of time it wanted to. But with this, it really gives both owners more options on what they can do with their unit once a swap has occurred. So it really is intending to give more options to both Wheeling as well as Kentucky.
And along those lines, do you recall questions earlier today from Mr. West in which he asked you about certain potential, gave examples really of potential alternatives?
Yes, I recall that discussion.
And as you recall those options, are there any one of those that the company has, company desires to do in the future?
Company has not laid out any specifics. In the CCR ELG case last year, there was analysis done. I believe it did show that this slightly higher cost for spending the ELG, but the numbers were actually very close. But no decision made on what that outcome is, other than the orders from this commission so far.
And there were a number of things, a number of economic alternatives offered, for example, some kind of pay-as-you-go option. That's just one example, isn't it?
Yes. So, yeah, there, as I mentioned, options around how you pay for ELG could be done any number of ways. And I was really just trying to give illustrations of the ways you could pay for it, but that's really the point of this new approach. It gives you options. Nothing is worked out in advance.
And so, any options, really Kentucky Power couldn't do those unilaterally either, correct?
No, the options have to be worked on by both parties in a mutual agreement.
And then you'd imagine approved by both commissions.
Correct.
Mr. Haynes, do you remember questions from Ms. Vinsel related to the timing of approvals for the unit interest swap?
Yes.
And there are some timelines in the revised agreement, aren't there, for when parties might need to negotiate or file?
Yes.
And really, can you just comment on those? Are those absolute windows within which timeframes have to happen, or do the parties have more flexibility?
Really, the idea is to give some dates of indication because, again, PJM, under its typical process, has certain dates by which you would need to indicate capacity for the future. So these really were intended, again, to be more drop-dead dates, but they're flexible for the parties to decide when you need to start and make sure you leave time for regulatory approvals.
And so the parties could also leave more time if they thought the situation was more complicated and required more lead time.
Absolutely.
And do you also remember some questions related to the arbitration provision?
Yes.
Okay. And do you remember questions related to how it worked and it required choosing one option or the other option, and the arbitrator couldn't choose a third option?
Yes.
In your experience, how does that impact the parties and what they do in arbitration?
When parties are in arbitration and they know that it's, one proposal or the other, if they come in from a proposal that is very extreme, then that is a greater likelihood of not being chosen. So especially when the example was given of price, I really should have said that you wouldn't come in with one price at $1 and another price at a very extremely high price, and then realize it's one or the other, and both of us feel like losers, but we might want to come in with a proposal much more closer to a middle price so that we're more likely to get chosen.
And so, just in summary, then, you'd say it tends to force the parties to be more reasonable at the outset?
Correct, as opposed to being on an extreme position that may not get chosen.
And the parties, depending upon the issue, could choose to deviate from that and also allow the arbitrator to choose a different option if they wanted to.
Yes, absolutely. Again, that's the point. The arbitration is only there, again, similar to the other structure, as a backstop if we can't agree on one issue or multiple issues.
And to that point also, right, this arbitration provision that we're talking about, which I think is section 12.4, it relates to only the unit interest swap, is that correct?
That's correct.
And so if you're gonna, should the parties be thinking about that as a contribution to that overall decision of the unit interest swap?
Make sure I understand your question.
Sure, I'll clarify. The parties will negotiate the unit interest swap for the terms of the agreement.
Yes.
And if they have disagreements in that, what do they do?
Well, if they have disagreements in that, they would take whatever the disagreements are to the arbitration.
And so in that sense, it's an input into their decision.
Yes, they know what might happen if we can't come to terms.
And when they're done making their decision and that the terms negotiated, what are they then required to do?
Then they would be required to go to the arbitration if we can't come to an agreement.
Yeah, assuming that they've reached an agreement and they're done.
Oh, then we go to the regulatory approval process, and then we hopefully conclude.
Right. And so at the end of the day, it all comes before the commissions, doesn't it?
That's the intent.
Right. And, you may also recall some questions also, I believe, from Ms. Vinsel about the regulatory bodies that would be required to approve this kind of transaction.
Yes.
From your experience in transactions, including, the current proposed Liberty transaction, there are many different government entities that might need to approve such a unit interest swap. Would you agree?
Yes.
Could you give some examples?
Yeah, for a unit interest swap, again, depending on the dollar amounts, you could end up with Hart-Scott-Rodino, you could end up with FERC, and as well as the state commissions, and it could be some other bodies as well, depending on permits and other things.
And is it your expectation that if Kentucky Power and Wheeling Power were the owners to a unit interest swap, what would they have to get authority from Kentucky and West Virginia commissions?
Absolutely.
I don't have any other questions.
At this time, does anybody have any objection to making KIUC Confidential Exhibit 1 from the 2021-0081 case, a hearing exhibit in this matter?
No, Your Honor.
Okay. We will get a copy to the reporter, but if that's the case, that's the document that was referenced earlier on.
Right, and the intent is to make it a confidential
A
exhibit.
confidential hearing exhibit in this matter,
And
that's
we
right.
don't need to file a motion.
We'll take care of that. We'll have it as a hearing document, and, it's a good point.
Yeah.
We can issue an order on our own motion.
We can give a
to-
post-hearing order.
Yeah, we can do that to provide confidential protection to a
Thank you.
document. Yep.
Thank you.
That it falls into one of the exceptions of the Records Act, Open Records Act. Yeah, I think we can do that in our own motion, right, Ms. Vinsel? We'll take care of that.
Thank you.
One less thing for you. All right. So if there's no objection to that, thank you, Mr. Haynes. You can step down for a minute. Is there any other witnesses from the company, from the applicant?
No, Your Honor, not
Okay.
at this time.
Is there anything else to take out?
I think Mr. Collin is next. in the-
I just meant with your case.
I don't think so.
No, I don't think so.
No.
Okay, great. Mr. West, Mr. Kurtz, would you like to call your witness?
Yes, the Attorney General calls Mr. Lane Collin, who's a joint witness for the AG and KUC.
Mr. West, you'll be introducing the witness?
I will.
Mr. Collin, please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Please have a seat. State your name and address for the record.
My name is Lane Collin. My address is J. Kennedy and Associates Incorporated, 570 Colonial Park Drive, Suite 305, Roswell, Georgia 30075.
Mr. West?
Thank you. Mr. Collin, have you reviewed the filing that the company made on March 15th, 2022?
Yes.
And can you describe that filing?
It requested an amendment to its initial application and essentially a substitution of the original proposed Plant Mitchell or Mitchell Plant ownership agreement with a substituted version of it.
Okay. Do you have any concerns regarding the revised ownership agreement?
Yes, I don't think that that ownership agreement effectively addresses some of our core concerns with the original proposed ownership agreement. The first concern being that we don't believe it's necessary. The existing the existing operating agreement already has ownership provisions, and that operating agreement could be extended. Or the allocation of capital expenditures, for example, the ELG expenditures directly to Wheeling Power Company could be expressly addressed in a modified operating agreement. We do not see a need to structure a downstream transaction before a transaction has been presented to the commission to either set up a process for a transaction or the structure of it, or in essence predefine the outcome.
Do you have any concerns regarding the revised ownership agreement as it relates to decommissioning costs?
Yes. Many of these issues remain open-ended. The proposed amended ownership agreement does not resolve these issues. It simply sets forth a list of issues in Exhibit C that would be negotiated by the members of the operating company, two operating companies. One representative from Kentucky Power Company and one representative from Wheeling Power Company, but there's no resolution of the issues that we raised in with respect to the original proposed ownership agreement.
What about any apportionment of tax savings? Does the agreement speak to that?
It does not. And in fact, even beyond that, to the extent that there is a unit interest swap, and ultimately the negotiations within, between the two members of the operating committee go that route, we have no idea what the structure of the transaction would be, whether it would be a like-kind type of exchange, whether it would be a purchase and sale between the two entities, what the tax implications would be. Ultimately, the transaction would have to be brought before the commission. So that brings us back to the major point that I made initially, and that is, why would you structure a transaction or have an agreement to structure a transaction and ask for the commission's approval of that unless and until you actually had a transaction that was negotiated to bring to the commission for approval?
Are there potential rate-making consequences for the structure of the transaction?
There are. If there's a gain or a loss, for example, the purchase price for Kentucky Power may be Wheeling Power's net book value, or it may be something else. We don't know. We don't know what the transaction structure will be. And the company has acknowledged that they don't know either. And yet, this commission is being asked to approve a structure of a transaction without a transaction.
What about what's been referenced previously as a make-whole? Does the revised ownership agreement speak to a make-whole payment?
It does address some form of compensation, but it doesn't specify that, what it would be. And again, there is no transaction at hand here. And yet, the commission is being asked to approve the form of a transaction agreement, an agreement that has a form of a transaction embedded into it without an actual transaction.
Do you have any other concerns that we haven't covered?
Well, I think that all of the, or most of the items on Exhibit C to the amended ownership agreement are subject to negotiation. And then presumably, if there is a transaction with a unit interest swap, that presumably that transaction will be brought to the commission and the terms and conditions at that time. And that would be appropriate at that time when there's a transaction in hand for the commission to consider. But with respect to the list of items that are still open-ended, these are all uncertainties that we addressed with respect to the original proposed ownership agreement. They remain unresolved.
Do you have a recommendation regarding the revised agreement?
Yes, I do not recommend that the commission adopt this amended form of the proposed ownership agreement.
Witness is available.
Ms. Vincent, any questions for the witness?
We just have a few, Chairman. Mr. Collin, I want to follow up again on a couple questions that Mr. West asked.
Yes.
He had hit on some of your concerns regarding the decommissioning costs and the ELG costs, but he didn't really talk much about the grant of power in the ownership agreement. Do you feel like the ownership agreement grants too much power to the operating committee?
Well, it does, subject to a subsequent review by the commission. And, the operating committee resolves between two people, one representative from Kentucky Power and one representative from Wheeling Power, some of what we consider the critical issues. And in fact, whether or not to negotiate a buyout transaction or not, or force it into a unit interest swap, which is what would happen by default. And then that structure or sequence of events is set forth in this proposed, amended proposed ownership agreement. And only then, if, depending upon whether or not a buyout transaction is negotiated or there's a unit interest swap, then it would go to the commission to consider. But those would be the only two options, as I understand it, that would come before the commission. And then, but it's a preordained sequence of events, either a buyout or retirement as another alternative, or the unit interest swap. And then the commission would have to review the unit interest swap and the things that arguably had been negotiated among the members of the operating committee.
Okay, based on that, what would you recommend the revisions be to change that balance?
Well, I think that the appropriate sequence of events is for the company to come up with a transaction and then bring the transaction to the commission rather than asking the commission to approve a sequence of activities that could lead to a transaction and then come to the commission to approve it. It seems almost nonsensical to go through that exercise rather than simply waiting until there's a transaction on the table and then bringing that transaction to the commission.
Okay, I have another question with regard to some of the questions Mr. West had, the tax implications. Could you explain the difference between the unit swap if it was a sale and a purchase versus a like-kind exchange?
Yes, there would be certain types of transaction structures where the transaction would be what it would be considered a true sale for tax purposes, meaning that particularly if it were between unaffiliated entities, and there then could be a tax gain and a cash tax expense on that gain, and then that would affect both companies, obviously. Kentucky Power Company and Wheeling Power Company, because they would each be having to report taxable gain and the taxes on the taxable gain. And that would step up their basis, but there are those aspects of it that nobody has even mentioned. And, it would be, I think, significant for purposes of rate making ultimately, particularly if, Kentucky Power ends up with a stepped up basis in one half of a unit, looking at it purely from Kentucky Power's perspective, which is really the commission's perspective here. And presumably the purchase, and this isn't clear, but presumably the purchase of the 50% interest from one entity by the other entity for each of the units would be at something like net book value, presumably.
Okay. The next few questions are going to refer to some of your direct testimony that was given. I think in the other, is it the other case? From the other case.
Okay.
Yes, from 481, sorry.
Yes, I understood which case, yes.
According to your direct testimony in that other case, you read the ownership agreement as to require Kentucky Power to sell its interest to the Mitchell plant to Wheeling Power. Do you think the amended ownership agreement also requires Kentucky Power to sell its interest to Wheeling Power?
I don't believe that it does. There first is a negotiated buyout transaction. If that is not successful, the parties can mutually agree on the retirement. But then, if they don't agree on the retirement and the buyout transaction is not done, then the amended proposed ownership agreement does indeed require moving into this unit interest swap. So maybe it's not clearly a yes or no answer like my initial response to you was, but there's the three options. But essentially, if you're not going to retire the unit and you don't reach agreement on a buyout price, then there will be a unit interest swap transaction. It says the amended proposed ownership agreement says shall.
That's all I have, Your Honor.
Vice Chair?
Yeah. Hello, Mr. Collins.
Good afternoon.
I just wanted to confirm, in your original testimony before the amended application was filed, you had recommended rejection of the ownership agreement, but also indicated that you didn't think the O&M agreement as drafted could move forward, and you recommended, and if you want your testimony, we can pull it up, but it's at lines 13 through 15 on page, I think it's page 35, where you state, as I previously discussed, the better approach would be for the companies to extend the existing operating agreement either informally or formally.
Yes,
Do you
yes, I
still-
recall that, and that's still my testimony today.
Okay.
There already is a provision in the existing operating agreement for the disparate sharing of costs. And to me, that's sufficient. There can always be more detail around that, but that's something that presumably would be within the purview of the operating committee. And Wheeling Power has already spent dollars on ELG in terms of the planning and design of the work that will be done. And so that distinction already is in place pursuant to the present operating agreement. And in my assessment, you don't need an ownership agreement to do that. That capability already exists. But the operating agreement terminates by its terms if one of the companies ceases to be an affiliate. So my recommendation with respect to the original, and still the present operating agreement is, the easiest thing to do is simply extend it.
Okay. If it were extended, would the operating committee be able to change the operator to Wheeling?
I think that would have to be a modification of the present agreement. That's true. That is true.
And presumably, the operating committee might need to be reconstituted since it's got, the tie-breaking vote is essentially AEP Service Corp., if I'm remembering right.
That's a fair point. I hadn't thought about that, but that is a fair point, yes.
That's all I've got. Thank you.
You're welcome.
Mr. Crespo, Mr. Overstreet, do you all have questions for Mr. Collins?
Yeah, okay. Just a few, Your Honor.
You know, figure out who's gonna go.
We got it.
Good afternoon, Mr. Collins.
Good afternoon.
I listened with interest to your direct examination by Mr. West. What I heard, and would ask you to confirm, is that with respect to the ownership agreement, your concerns are limited to Section 9.6. Is that correct?
The original ownership agreement?
No, I'm sorry. We're just talking about the one that was filed with Mr. Haynes's supplemental testimony, the amended ownership agreement.
The amended ownership agreement, no. Our concerns are with the, backing up for the need for an ownership agreement.
Okay, so when you testified here on March 1st, I thought in your written testimony filed before that, your concerns were, with respect to the ownership agreement, were limited to Section 9.6.
No, they were not limited to that. That was one of the concerns that was listed, but my recommendation was to deny approval of the proposed ownership agreement altogether, not to try to fix it.
Okay, what are your other concerns? Can you point to the other sections of the amended ownership agreement with which you have concerns?
Oh, of the amended ownership agreement?
Yeah.
First of all, it doesn't bring certainty.
No,
It-
I'm asking about specific sections of the ownership, of the amended ownership agreement.
Right. We can talk about Exhibit C, where there's a list of items that will need to be addressed by the operating committee, the representative of Kentucky Power Company and Wheeling Power Company. There's no resolution of the tax issues, the type of structure that the unit interest swap would take, whether it would be a like-kind type of exchange or, a sale and purchase. All of these things that allegedly would bring certainty down the road after an agreement is negotiated certainly do not bring certainty through the amended proposed ownership agreement. And that, kind of goes full circle to the, if you have a transaction, bring a transaction to the commission. Until then, where is the certainty? What value is this amended proposed operating or ownership agreement?
Okay, so the existing ownership agreement,
There is no.
I'm sorry, the existing operating agreement, it doesn't address questions about like-kind exchange or tax consequences of a sale or anything like that, does it?
It does not, nor does it need to. And, but it does address disparate capital investment. And if the parties want to negotiate an agreement, some type of transaction, whether it's a unit interest swap, whether it's an outright sale, then they can negotiate that transaction and bring it to the commission. That seems to me to be the logical sequence. Rather than trying to preemptively address a transaction sequence and maybe the broader form of the transaction, whether it's a sale or, and the pricing structure under the original proposed ownership agreement, or whether it's under a unit interest swap under the amended ownership agreement, it seems to kind of be putting the cart before the horse.
So, again, the existing operating agreement doesn't address issues like like-kind exchange, is that correct?
It does not, nor does it need to.
But presumably, at some point prior to 2028, the owners of the two undivided 50% interest are going to have to resolve these issues that you insist are being prematurely addressed now.
I agree with that.
And-
They will have to be resolved.
And-
And my assessment is that some type of resolution should be negotiated between the parties, and then that transaction, the resolution transaction, can be brought to this commission, the West Virginia Commission, as well.
And there's nothing in the proposed ownership agreement that prevents that exact sequence occurring, is there?
Well, I would disagree with you, because it sets forth a sequence of events. First of all, a negotiated buyout transaction, and that could happen at any time with or without that amended proposed ownership agreement. But then, if the units are not retired, then it shall move to the unit interest swap. And so it does, it establishes a sequence. And I just don't see a compelling reason for that. And I think it's putting the cart before the horse.
You've heard the expression, allowing the perfect to be the enemy of the good.
I have, yes. I'm not sure that applies here, but go ahead.
Again, there's nothing about you object to the various options available and then the manner in which those are laid out. That's the substance of your objection, isn't it? That you and I just discussed here.
Those are aspects of my
Okay.
opposition to the amended proposed ownership agreement.
And is there anything that, in the absence of the proposed ownership agreement, that would prevent this commission, strike that, if this commission were to approve the proposed ownership agreement, the commission still would have to determine whether the resulting disposition was an appropriate one in terms of tax consequences.
That would be one aspect of the inquiry by the commission, presumably.
And there's nothing in this agreement that in any way limits the commission's jurisdiction, is there?
I don't know if I can actually say that, because there are certain aspects of it that well, first of all, the sequence of the transactions is set forth in the amended proposed ownership agreement. And then the operating committee, if it moves to the unit interest swap option instead of the buyout transaction, then the operating committee negotiates all of the terms, and then the outcome of that is that there's a review by this commission and the West Virginia Commission. I'm not a lawyer, but it seems to me that if the commission were to approve this sequence and this amended proposed ownership agreement, then there may be some claim by Liberty or by Wheeling Power that somehow it's restricted to only looking at those forms of transaction. And,
But you
those
heard
types of
Mr.
things have happened before this commission, where the utility has come in and said, sorry, you don't have any choice.
But you heard Mr. Haynes this morning speak to that very issue, and that nothing in the proposed ownership agreement limited this commission's jurisdiction. And if the commission decided that it felt like the buyout price was too low, if that was what was negotiated, or if this commission decided that it didn't like the notion of a unit swap, under the applicable statutes, chairman's identified some, Ms. Vensel's identified some, it could reject the transaction, couldn't it?
Well, I think that the commission would retain the right to reject the transaction, but to the extent that it approves this amended proposed ownership agreement, it seems to me that it's approving the sequence of the negotiation and then the default of the unit interest swap. And in other words, that's something then that it would have previously approved, and it can review the details of that, but if it's approved that sequence of transactions or potential transactions, then I don't know to what extent it would be stopped from,
We're not talking estoppel.
yeah,
We're
no,
talking
I'm
about
just,
the
I'm using that
private-
in a layman's term, but I'm just simply saying that,
Yeah, well,
that may, in some parties' opinion, constitute a limited set of options for the commission to consider. And I don't think the commission needs to go down this path at this point and lock itself in any respect.
But this agreement, I thought I heard you say, wasn't locking the commission in, that it retained its full jurisdiction, and this
Yeah.
was, and wouldn't you, if that, I heard you correctly, then all this involves is two entities structuring a very complicated event in a way that's transparent, that the commission gets to look at now, and then gets to decide whether the parties did it right whenever it's brought in front of it.
No, I disagree. I don't think that that's all, as you use that term, that this represents. Otherwise, I don't think the company would be so actively pursuing this proposed ownership agreement. Because if all options were on the table, there'd be no reason for this. If you have a transaction, bring it to the commission. If you don't, then why do you need an ownership agreement?
Okay. So you mentioned the rate-making consequences, right?
Correct,
That was
yes.
one of your concerns. But again, the commission decides when a rate case is presented to it, those rate-making consequences. Is that correct?
Well, that's true, but if there's a transaction structure that was formally, in essence approved through the approval of a proposed ownership agreement, then, all of these aspects are really tied to that, effectively, approval of that sequence of transactions.
And then the same thing for decommissioning costs, right?
The commission, as I understand it, would have the opportunity to review these costs, but, there could be arguments by some parties, namely Kentucky Power, that the commission's approval of the proposed ownership agreement essentially locks in some of those costs, despite Mr. Haynes' protestations that it does not. I mean, ultimately, whatever the commission approves in terms of a proposed ownership agreement, if it approves one, that will be open to debate as to the scope of the approval, ultimately.
Is it your position that if the, one second, please. So if the parties, if Wheeling and Kentucky Power are unable to reach an agreement on how to resolve the issues presented by the conflicting decisions of the West Virginia and Kentucky commissions, is it your client's position that the unit should be retired?
I think that, is a decision that doesn't need to be made today. In other words, if there are alternatives that either the operating committee can discuss or, Kentucky Power could bring to this commission as to whether to continue operating, and essentially enter into some type of agreement or transaction deal with Wheeling Power Company on renting, for example, the ELG facilities, or retirement. Those are decisions that can be made down the road. They don't need to be made today.
And that's the fact is, well, but at some point, if Wheeling and Kentucky Power cannot reach an agreement on how to handle the 2028 date and the requirement that Kentucky Power essentially get out of the unit under the current orders, how does that happen in the absence of an ownership agreement when Kentucky Power has an undivided 50% unit in the entire plant?
Well, that's something that will need to be addressed. There's no question about that. But to first of all have this proposed ownership agreement with an identified series of potential transactions at this point, and then to make it a condition of the stock purchase agreement, seems to me, I can't see a compelling rationale for that. Yes, something needs to be done at some point in the future, but I don't see a compelling reason why it needs to be done by May 5th.
Well, you could understand why you agree that the current operating agreement was drafted to address the operation of the unit when it was, the two undivided owners were affiliates.
Yes, that's correct. I mean, that's a factual matter.
And if the commission were to approve the transfer of Kentucky Power in 481, that would no longer be the case, correct?
The two companies will no longer be affiliates. That's correct.
And you would understand, would you not, why an agreement that might work for affiliates wouldn't work for unaffiliated companies?
Well, I think that there do need to be some modifications to the existing operating agreement. The vice chairman pointed out one with respect to the operating committee. The allocation of capital is really under the control of each owner at this point pursuant to the existing operating agreement. And there may be some other modifications that need to be reflected in that operating agreement, but I see no compelling need for a new ownership agreement.
So is compelling need, is that the standard?
Well, I think so. I mean, to find that there is, first of all, a need for an ownership agreement beyond, a simple allocation of capital, particularly one that establishes a timeline and a sequence for addressing the resolution of the ownership of the units and the disposition by each of the companies, I think is premature and something that doesn't need to be decided by this commission by the beginning of May of this year.
Nothing further.
1 second. Hold on 1 second, Mr. Schweiger. Sorry, do you have much redirect?
No.
Do you have any redirect? Okay, all right, great. So we can, no redirect?
No redirect.
Okay. Let me know when you're ready, Mr. Schweiger. Because it's been a long day, just the third time. No redirect to Mr. Collins.
I have
All right.
no redirect.
I just want to make sure I'm clear before I start down another path. And there were no exhibits referenced in the director of the cross-examination of Mr. Collins, correct?
That's correct.
All right. Is there any reason why Mr. Collins can't be excused?
There's no reason.
Show of restriction. No objection. Thank you, Mr. Collins.
Thank you, Mr. Chairman.
In opposition to what I said earlier, opposite of what I said earlier, I have no additional questions for Mr. Haynes, but I would like, you all mentioned it, so I just wanted to make sure that you all didn't request Mr. Haynes to retake the stand in rebuttal to anything that was requested or asked of Mr. Collins.
No, Your Honor.
Okay. Is there anything else? Mr. Kurtz? No. Mr. West, that you all, no additional witnesses, nothing you would like to bring up? Okay.
All right.
So I guess the question is, in terms of process, where do we go from here? Certainly your application, Mr. Overstreet, your client's application, should be permitted if you'd like to make legal arguments in support, or arguments generally in support of your application. And same for the KIUC and AG in support of your position. Do you have an expectation or interest in filing any memorandum briefs?
I think we do.
Yes, Your Honor.
And today is
30th.
March the 30th. Given the certainly aggressive schedule that we set yesterday for the 2021-00481 matter, but given Mr. Haynes's certainly point that these are related and there's an interest in expediting is the wrong word. I take the AG and KIUC's point on that issue, but certainly there has been a request to review these in short order. Do you all have a proposal as to when you can file a memorandum brief in support of your application?
We were thinking to follow follow the structure. I know it's a bad word here, but the structure of what we did in the 481 case, have initial simultaneous briefs and initial rebuttal or responsive briefs with the initial briefs due on 15th of April, same day I'm doing my taxes, and the rebuttal on the 25th, if that works for the staff and the commission.
What is your opinion on the issue, Mr. Kurtz, Mr. West? Well, first, do you have an opinion on the rebuttal versus initial response reply?
Was the proposal simultaneous initial briefs with one response?
Simultaneous initial briefs with simultaneous response briefs.
We're fine with that, and I would just like to express regarding yesterday that the reasoning for potentially a single brief yesterday was related to our extremely limited schedule. That's why we had thrown that out as an option, but we have no problem with initial simultaneous briefs and response.
Mr. Kurtz?
Yes?
Is there any objection to that schedule, Ms. Vincel?
Well, staff does not object to the schedule, but it may be aggressive for getting orders out in a timely fashion.
Oh, yeah,
so-
I don't disagree. There's almost no way we get an order out on May the 4th if we get response briefs on April the 25th, especially given our requirement to have an order out on the statutory date for the 278, under 278-0207 for the 481 case. Now, I would offer, there's 10 days between there.
Your Honor, would it assist the commission at all if the reply briefs were due on the 22nd? Will that be a meaningful difference to the
Well,
commission?
it would, but I don't know that 7 days for the responses. So here's the thing. So, as opposed, and this is just my personal perspective, but as opposed to the hearing in 481, you all, as I see it, had the entire burden in this case. All they are really saying is we disagree. As opposed to the 481 matter, which you all have effectively an affirmative position, a specific proposal as to what you're requesting the commission to do, which is why I was lending myself to provide simultaneous in the 481. If you all could file an initial brief.
Mr. Chairman, can I interject?
Go ahead.
After briefly conferring, we would like to reiterate, just as yesterday, that we think we could effectively present our position in a single brief, if that would help speed the process along.
Yeah, so, it might, only because what I'm about to offer is, if you all can, before the 15th, file an initial brief in support of your position, the interveners file a single brief on their position in response, and you all have, I don't know, a few days to file a reply brief that may, one, at least with the initial arguments of all the parties involved, help us to begin drafting an order, and then we can, obviously take into account your reply brief.
So these would no longer be simultaneous
It wouldn't be
briefs?
simultaneous.
Well,
It'd be initial response, reply, and the reply would be limited to anything brought up in your response.
Right.
And your response would not necessarily be limited, but it would be in support of your arguments.
responding almost makes it harder for us from our position. We have an idea of what our position is, and we would like to go ahead and start writing our brief.
Nothing keeping you from writing it.
I understand, except the fact that we don't know what they're going to say and what we have to respond to. So, again, we would propose one simultaneous brief.
Okay. If you mind, 1 second.
Your Honor, while you're looking at the calendar, I'll also mention that there are the posterior data responses and requests in this. I know you're aware of that, and that may reflect those dates as well.
Correct. So how about simultaneous initial and response briefs due the 12th and the 19th?
That would put the briefing in this case,
13th and the 20th. I know what you're going to say. The 12th and the 18th was the process in the other case.
right, I
Chairman,
just wanted to remind,
Did you reject the AG's proposal?
Yeah, I think that we have a preference for having a response to arguments, legal, especially our legal arguments that are made.
Understood?
And that's a personal preference, but I think that's a preference that, here's the issue, as I see, with just filing one brief. I've seen it done plenty of times where people are perfectly happy filing an initial brief. And then somebody says something, or just a single brief, and somebody says something they want in the other, and then we end up with a motion practice for everybody wanting to file leave to supplement their brief or to address something that they didn't know the other person was going to bring up. And with everything else that we have going here, it's just not a risk I'm willing to take in any proceeding, never mind these two. That's the issue. The best that I can do, Ms. Blend, Mr. Crespo, because I know Mr. Crespo, I suspect, is going to be busy with Ms. Knowlton on a couple of other things during this time period, is an initial on the 14th and a reply on the 21st.
Yeah, that's acceptable, thank you.
Those are simultaneous,
Simultaneous initial, simultaneous response.
14th and 21st.
April 14th, April 21st.
Your Honor, could I make a recommendation or a proposal regarding posterior data responses?
So that's what I was wanting to do, is set the briefs and then be able to work backwards on the data requests. So with the data request, Ms. Vinsel, do you have very many?
I think it's a grand total of 3.
Okay. Mr. West, you have the one, which the one is the AAA.
Correct.
I don't know if they go by AAA. I suspect there's a copyright issue there, but the arbitrator's agreement. And do you all have any post-hearing data request of that you all respond? Okay. Ms. Vinsel, when can staff have the data request?
We can have them out by April 1st.
Okay. Mr. West, can you get your one out by April 1st?
Yes.
And Ms. Blend, Mr. Crespo, Mr. Overstreet, you all have heard what the questions were today. Can you have those responded to by April the 8th?
Yes, Your Honor.
So, as I see it now, the post-hearing data request will be issued 11:59, April the 1st, to be responded to by April the 8th. Initial memorandum briefs in support of positions, simultaneous briefs, will be due April the 14th, with simultaneous responses, if you so choose, by April the 21st, whereas 12:01 on the 22nd, the case will be submitted. Is there any objection to that schedule, Mr. Crespo, Mr. Overstreet?
No, Your Honor.
Mr. Kurtz, Mr. West? Okay. Now, I do want to make sure, I know we've worked, but I do want to make sure that I make clear, I'm under no impression, correct me if I'm wrong, Vice Chair, that we've committed to a May the 4th date in regards to the initial application or the amended application or the agreements here. I know we have a statutory date, of course, in the other matter, but what we work towards and what we get and what happens is we've not committed. I just want to point that out. So I don't want any of the comments I've made this morning to as Mr. Overstreet reminded us about Mr. Melanikovich's comments, to WFPL, the commission can only speak to its orders.
Yes, Your Honor, and we appreciate your sensitivity to those things.
All right. Is there anything else we need to do before we adjourn? All right. Well, thank you all for the patience the last couple of days. This hearing will be adjourned.